Court officer. Court officer. Sir, ಇದು Honorable Justice Lalita ಅವ್ರ ಕೋರ್ಟ್ ಅಲ್ಲ?
year is that?
2022 matter.
What orders? Ultimately, you have to go for the execution.
Please.
Then what is urgency for it? We'll see. That's not a
There he
urgent
is
matter.
mentioning that matters pending before the High Court.
For
So-
EP court will know whether there is a stay or not if you file it. Yes.
Matter of pending below, there was direction issued by the Sample Court for deposit of 20,000. Till today, they are not deposited below. There are more than 10 lakhs arrears as per the sum of calculation filed by the respondent.
Interim order is not complied with.
No, my lord, they have complied below, partially they are not, as per the direction issued by law, 80,000 is.
Pose this matter next Tuesday. Yes.
That for respondent, they have deposited the money, and withdraw that money from medical.
Tomorrow.
Appellate, my lord, and cemetery, my lord, there's construction in our time side, so can we post this matter for admission day after
Which year is that?
24th?
Yes.
Withdrawal, my lord, I mentioned.
My Lord, this matter, my Lord, the entire building complex is stayed by a third party. After 20 years, my Lord, he comes and says that his ancestors have some right in the property. Based on that, my Lord, the suit is rejected. An interim order is passed, my Lord, staying the operation of that order. The entire building construction is stopped, my Lord. A
In
frivolous
MFA
case is
In
filed.
MFA stay is granted.
Please, my Lord,
Let's take that. Yes.
grateful, my Lord.
Yes. All the list.
My lord,
Serial
serial
number.
number 6, my lord.
Hmm?
Serial number 6, my lord, and for the appellate. The impugned resolution and the other annexures are in Kannada, my lord. We'll place the translations before this court. We see 2 weeks.
It is submitted that the impugned order is in Kannada. They'll file a translation. Pose this matter after 2 weeks.
Serial number
bless.
7, please, my lord. Inform the appellant, please, my lord, I mean, for the respondent. There is inconvenient to the senior student, my lord. 28th, my lord.
Pose this matter on 3rd of September. At the request of learned counsel for the appellant. Yes.
It's in serial number 9, my lords, and the respondent is proceed for the limited issue of filing an affidavit with some information. The authorized signatory of the company wasn't able to sign the affidavit, my lords. If 1 week's time can be granted.
Inform the other side.
And
Yes. Pose this matter. I think was it argued?
it was
Please, my
all-
lords.
Pose this matter. Oh, that is with regard to
For
the,
purpose.
pose this matter after a week for filing the affidavit by the respondent. If no such affidavit is filed, the matter will be heard on the merits of it. Yes.
Grateful, my lord.
Date may be fixed. Lord.
It will come on 3rd of September. Yes.
Grateful.
Serial number 13, my lord. Under caveat, objection has to be filed and
My lords, I have to,
objection has to be filed.
Go for the appellant.
yes, my lords. But
So
someone,
why caveator wants adjournment? First of all, giving notice itself, that's over. No, it's for the, between the court and the, yes, you don't have any objection?
I had to produce some documents, my lords. I don't have objections.
Hmm.
But my lords, can I request on Monday, my lords, because construction is going on, my lords.
Monday is a holiday.
I'm sorry, Tuesday, my lords.
Pose this matter on Tuesday at the request of learned counsel for the respondent.
Obliged.
Serial number 19, my lords, for the appellant in this case.
19,
Please, for the appellant, the impeding applicant is withdrawing their application. For the impeding applicant, filing a memo for not trusting that application. Appeal is filed. Sending the renewal of the appellant from the service of Archaka of the temple. Today, there are no Archakas, the temple is facing some issues. Therefore, I'm not trusting that application. Application may be dismissed as not trust.
I have 1 of 23 is filed, do that. 1 of 23 is filed to implead implead them as parties to this. Is it so? I have 1 of 23 is filed by him
Please, no. Whether
To
respond number 5.
to implead them as proposed R5. And it's filed by whom?
Filed by me. Based on my complaint, proceedings has been initiated against the appellant. And he has been
Who are
removed.
you?
And native-
Trustee,
No, ma'am. I'm
It's
the
the villager.
villager of the temple where the temple is situated. It is a 12th century's temple.
and you will be impleted in MFA.
Please, ma'am.
We'll see when that MFA reaches, yes. Yes,
That's serial number 9.
Well, I'm serial number 24. I may kindly be permitted to take the file to amend the cast title, my lord, because I have already filed amended cast title on 13th February, only to carry out the amendment of own apology, my lord. I am
Yes,
my
yes.
mistake. I may kindly permit to
yes, yes.
take the file.
yes.
It's 32, my lord, serial number 32 for appellant. Lord, it's a pecuniary jurisdiction, my lord, I have to file before a district court. May permitted to withdraw, my lord, with the liberty to,
Is this in the light of the amendment or
no, my lord, the.
even
juris-
prior to that also?
Please, my lord. Yeah, that's also
Okay,
office
submit.
objection.
You
that-
realized it in 2024.
No, my lord, I thought it's from the junior division, they have to file to a district court, my lord. They valued for 8 lakhs. My lords,
No, the office also not raised any
they
objection.
raised the objection regarding jurisdiction, my lord. I just verified with them and they asked me to get the violation slip.
No, from 2023 to 2024, now you will get the limitation.
That limitation,
Go.
that
Can it be?
under section 14, my lord.
You've done it long back.
Please, my lord, I just realized later.
The MFA is filed. The memo is filed, seeking to withdraw the petition. It is withdraw the appeal. It is submitted that the office has raised an objection with regard to the maintainability and the appeal lies to the district court. In view of the same, the present memo is filed seeking liberty to file the petition before the district court, file this appeal before the district court. Accordingly, the memo is taken on file. And the appellant is permitted to withdraw the petition is dismissed as withdrawn with the liberty to file an appeal before the appropriate court. The registry is directed to return the original records.
Yes, obliged.
My lord, serial number 38, my lord.
Hmm.
I'm for appellant. I need one short 1 week time, my lord, to take steps against R3. my lord.
For taking steps, a week's time is granted, same default order. If the same is not complied. Yes, next.
Obliged.
I pay for the appellant in this matter, my lord. Lordship disposed of the matter on 14.
Yes,
Here, actually, there is no commercial dispute between the parties.
let's see that.
Lordship, may kindly see,
Give the circular also. Come to the,
yes, my lord. Lordship, may kindly see that office raised objection. Lordship, may kindly see page number 14. There it is mentioned that court of fourth additional district judge and commercial court. Based on that, office raised the objection. For that, I would like to make a submission. There is no commercial dispute between the parties. Land of the first respondent acquired for the formation.
then why did you go to that court?
Lordship, may kindly see. In that
Give the
particular,
circular.
Lordship, may kindly see again, page number 34, my lord.
Please look at the circular that is given.
Before that, my lord.
No, that is first.
That is only meant for commercial court. As far as this-
No, what it says, let's see, what is the
But
circular?
these matters are not before the commercial court, my lord. Lordship, may kindly see.
No,
where-
that we will, please understand, what is the circular? Have you seen the circular?
Yes.
You have the copy of it?
Don't have the.
What it says?
Wherever the matters are filed
No,
before
it
the
says-
commercial.
To take up cases appeals with nomenclature as commercial appeals with observation COMAP arising from the orders, judgments, decrees passed by the commercial courts
Submission
as
is-
provided under
Yes,
section.
my submission is that this honorable court, district judge, not a commercial court. Page number 30 may be seen, my lord. Where
No, the list of the courts is also annexed to this.
But in that particular court, regular matters as well as commercial matters are handled by that particular district judge. It is not a special court for commercial court. Lordship, may kindly see the page number 30, where a judge signed as.
What is this, which is the court? Courters?
District and session judge Mangalore.
Fourth additional district and session judge T.K. Mangalore.
Yes, Lordship, kindly see page number 30, where signature of the judges. there. There it is only 4th additional district and session judge and decree also, Lakshmi kindly see, page number 32.
Page number?
32. 32 of the appeal.
Hmm.
There also in the court of the 4th additional district and session judge Mang. Moreover, there is no commercial dispute between the parties as defined under section 2A of the Commercial Court Act. It's a regular court only, maybe while copying that judgment, the first page is remained as it is. That particular court is dealing
It's a
with
designated court.
designated for commercial as well as district and session judge. Moreover, yesterday I argued one matter. There are similar matter, not only that, once division bench of this honorable court dismissed on that ground only. Thereafter, I filed a being spoken to me. This is the order.
Take that.
More than 200, 300 matters are pending pertaining to national highway acquisition. There are the same order passed. After that, I clarified that.
Please come. This court, the office has raised the objection with regard to the maintainability as this order is passed by the district and sessions judge Mangalore, DK Mangalore, which is a designated commercial court. As per the circular issued, as per the circular dated 30th October 2017, all the orders that are passed by the commercial court shall be treated as a commercial appeals. On that, the registry has raised the objection. When this matter came up before the court on on 14/8/2024, as appeal is, the impugned order is arising out of a commercial court, giving liberty to the petitioner, the office objection was sustained. Now the matter is placed before this court under the caption for being spoken to. Then counsel for the appellant submits that there is no commercial dispute between the parties. And in fact, with regard to the other appeals that are filed by the National Highways Authority against the award passed by the arbitrator, all those appeals are they are listed before the court as MFA. It is submitted that apart from the commercial courts, other regular matters are also heard by the said court. Considering the same, the order dated so on so and so on the maintainability is recalled. Post this matter for
Your objections I have to comply with.
that's what
Why
post this matter for admission once the office objections, all the office objections are clear or clear. Yes. Yes, next.
Respondent.
Oh, the other day she has come And
Please.
all the order, it is not what the court said, it is what she agreed. Whatever is comfortable for her, an order is passed by the court. Passed by the court.
Please, please.
Yesterday, and council mentions that because the order is not uploaded, she didn't turn up.
We will check. I did not know for what purpose.
No, just whatever, no, we will, where is the order?
Not may make one.
This order
Please.
is order. This order is signed by me, Mr.
Please.
Arun Govindpet. This order is, this is on dated 15th.
15th of July.
Final order is signed by me on 1st. It is sent for scanning, came back, and it is in a.
But that, no, that's all that, but she was present
No,
before.
no,
your
no,
lordship.
I
She's
was
aware of the
surprised.
case.
Long back I signed and you were asking yesterday that it is not uploaded. So then when I inquired, this is what it is. So now you have the order copy?
Sorry, I'm sorry.
Do you have?
We have not, it's not uploaded.
No, the order that passed the day was the father can exercise the visitation rights on every second Saturday and fourth Saturday in a month. On second Saturday after the school, the mother will take the child to the location where the father wants to meet, and there the father can exercise the visitation rights between 4 p.m. to 8 p.m. and on fourth Sunday between 11 a.m. to 5 p.m. Both the parties shall adhere to the timings. On fourth Saturday, the father can exercise visitation between 4 p.m. to 8 p.m. On all the days of visitation, mother will take the child to the place where the father wants to meet him. So, every clause in this is as per what she wants. How is it convenient to her? Accordingly, before her only this order is dictated that day. Then the next is the father can talk to the child on a video audio call between 7 p.m. to 7:30 p.m. The grandparents can also talk to the child on those days. The father is having the visitation. Time can be fixed convenient to both the parties. The mother along with the child shall come to Bangalore on, this is the one,
Please, please.
on 17/8/2024. She shall stay till 19/8/2024. On the morning of 28/2024, she can go back to Gwalior. I think this she has not complied with because the order is not out. She should have done it.
I should have done it.
Lord,
I will-
All the, 1 minute, all the dates, timings, everything, more or less dictated by her.
Sorry, I was not.
Whatever she said, that's
Basically, we are not
because-
there. my lords. We are grateful the honorable court spent time.
Then,
Now, the question is probably they are saying, I don't know what is.
Then is, while she is at Bangalore, the father shall provide accommodation to the mother. This also, whatever she asked, which is nearer to the place of grandparents, and mother shall stay in the accommodation. During the course of the day, as per the convenience of the boy, the visitation can be exercised. Generally, the mother has to drop the child at 10 a.m. in the morning and pick him up at 6 p.m. In between, if there is, this is also what she wanted. In between, if there is any difficulty, the grandparent shall facilitate the boy to speak to the mother. This arrangement is for both the August and Dasra vacation. Then coming to Christmas vacation, mother along with child shall come to Bangalore on 22/12/2024 till 25/12/2024. She shall stay in Bangalore, and on the morning of 26/12/2024, she shall go back to Gwalior. On the birthday of the father, father can go to Gwalior and spend time with the child as per the arrangement that is already made. During summer vacation, from the day she comes to Bangalore and the day she leaves to Bangalore, duration of 2 weeks has to be calculated. Father can have the first 2 weeks of the summer vacation. She said he can have first 2 weeks. Then coming to the car loan, installment shall be paid by the husband without fail, and whenever he finds buyer, on paying an amount of rupees 8 lakhs to the wife, the wife shall in turn hand over the transfer forms to the husband. Car, that's what she wanted. Father is ready to pay actual school expenses of boy and actual expenses of all the extracurricular activities. All the traveling expenses of the wife and son, and also accommodation in Bangalore on their stay shall be taken care of by the husband. Once the boy is comfortable and when he is ready for overnight custody, that time they can move an appropriate application before the trial court. What she was saying is, time and again, the applications are being filed and she had to engage an advocate and she has to, travel from Gwalior. So what arrangement that was is, except for seeing it for another 6 months or so, once the boy is comfortable, at that point of time, only one application will be moved seeking the overnight custody. Till such time, no interlocutory applications will not be filed. That's what was the arrangement. Now, what has to be clarified is, she has to come to Bangalore on 17/8/2024 and stay till 19/8/2024. So that is for 17th, 18th and 19th, 3 days. That time has gone now. That time has gone now. So when are we going to compensate that?
Let this be, I only pray that it's actually better that the husband and wife settle once for all these disputes. Otherwise, every time before the Honorable High Court, some memos and applications of this nature coming up.
But it's an odd, no,
May I pray
problem is, no,
that the
no, no.
registry be directed to upload this so that I will also get proper instructions. This registry be directed to upload it once. So I have the benefit of
No, actually,
advising.
no, this is not uploaded as of now.
and now you are asking me direct them, my lords.
No,
Directly.
instead of uploading it, if you can, that particular time and all, if she mentions, with that, now we will upload how many times again to here? What we'll do is, you please get instructions from her. This 17/8/2024, 19/8/2024, which she agreed. This is a consent order, unfortunately. No, it will be operating against her.
Unfortunately, for both consent is always better for the parties.
Consent order.
In matrimonial matters is
The
always.
consent orders. No,
best way.
because that is, now she has violated it. She has violated.
I do not know that this
She
actual
was very
situation
much
because it's
present
for
before
being
the court.
spoken to.
All the dates,
Yes.
everything that has been mentioned by her were, but that's what is,
But one thing, the husband goes on filing applications. Now he has
He
filed
filed.
application there in Delhi also.
application you filed.
Delhi has filed, he has moved, it's day after tomorrow, it's there,
That's all.
mediation
No,
center.
no.
No, series
I have
and
not-
trial court, everywhere, one of the other applications cannot be filed.
That's what has happened.
Applications are pending there in Gwalior. We cannot
No, no.
go on filing
This all
applications.
happened,
Please, please.
this all that day when the
Please,
parties were
please.
present.
No,
before
I
the
am
court,
grateful.
They
I'm
have,
not finding it.
they have,
but-
they have come to a conclusion that nothing will be done except the finally that matter will be, that's why everything, she asked for that maintenance, like, that extracurricular activities
Please,
and all,
please,
that. It
please.
seems what about it? He's
No,
paying.
she sends emails and I have paid it.
No, I don't want
For
one
that-
thing,
for that order copy,
all
not-
these
not-
husband, wife emails, I'm informed. Every time the emails are marked to the advocate, it's not proper. We don't want to receive any emails from the instructive counsel as a request, my lords. Every time they go on fighting each day and emails are marked to the advocate. This is not proper. We do not want to receive any
She
emails.
sends the emails.
No, opposite parties emails are, we don't require.
Her email, your lordship, I kindly
Let
say
them,
her
let them
email.
fight. Let them not send
For my
emails to
client's email,
advocates
Her email.
every time. This, every day, 2 or 3 emails.
Her email is.
Her
talking
email.
about-
Our emails, let them fight with each other, but
Her
not
email
take
to
the
both the
advocates as a
citizens.
party every time. No need to
Her
mark the
email to
advocates.
both
We are
the
not here.
counsel, not along with you.
No need to mark anything to the advocates.
your
Let them
lordship,
fight every time because
Understand.
this itself becomes a big book itself every time.
What
We
he's
can't
saying-
encourage this.
No, what he's saying is your client has sent the email to him,
No, let them,
to the
No, no, no,
advocate.
that we will advise. So we both them not exchange any emails to the advocates. Let them go on sending emails
What
every
I
time.
told- No. What I.
That is
told-
never ending because instructing counsel, dozens of emails every time between both of them marking to the advocates.
Counsel. Now, what I told her is,
Please.
she has some kind of, to talk to the husband and all. She has some reservations whether he will hear her or not or something. Then I said, you have some problem, inform him to the advocate, which Mr. Arun Govindraj has accepted it. That's how it's going. Like we are, when these kind of minute things, with some intervention, something can happen. We shouldn't feel it.
I
so
feel
much.
it's
Even
being aggravated. Every time it's being aggravated.
Email, we shouldn't, like they're.
It's being aggravated because the fight is going on. I felt one time that is going to end soon with the intervention of the advocates
But
because
she
we
sends
cannot
email about coding
advise the
fees.
client to
No, the
aggravate the situation.
The coding fees were not part of any interim order passed by your lordship. The coding fees or the extracurricular activities was part of the final order. She wants to, my lord, get the benefit of that order, and then she says, "There's no order copy. I will not come to Bangalore." But this kind of conduct cannot be appreciated. She's playing
Complaints
that-
against each
she's
other.
playing
I do not. I
second
will
to
take
court.
instructions on that point, but there should be some end to the repeated complaints.
It all went in her favor.
Please.
This
No,
order went
I'm
in
sorry.
her favor.
I wish that a copy be, I will have a copy so that I will also go through it. If my lord permits it.
No, no, Monday is a holiday. I will also put in the school calendar. Next Monday is a holiday. Before your lordship, she said Raksha Bandhan only 1 day holiday. In fact, today also is a holiday in Gwalior, my lord. Yesterday and today, 2 days are holidays. No, suppression of fact before the court, my lord.
No, who
We are
is
coming
suppressed
to
it? I
say-
don't want
we
to
are
make
coming
a-
Good faith before your lordships. Lord, there's
See-
the order of the domestic violence.
No, I do not know anything now. Let me an application.
Well, let's take my to make my submissions.
Right, well, without an
Small-
application, let them
small-
file,
no, no,
let there
small
be an
case, my lord.
application.
Domestic violence court dismisses their application for payment of car EMI. Before your lordship, my lord, we come and give an undertaking that we'll pay 1,30,000 rupees towards car EMI every month. Despite an order by the Gwalior court not dismissing her application. But we are showing our bona fides, my lord, before this court. She takes the advantage of your lordship's order and then says, I will not come to Bangalore. But what faith, my lord, will a litigant have if the other party, my lord, goes on violating the order repeatedly?
No,
My lord,
I do not want
Monday
to
is a
make any
holiday.
comments at this stage. I only pray that your lordship may permit me to this and mark me.
No, just one instruction
Please.
from her, please ask her to get instructions. Like, this order, why she did not comply with the order? Number
Please.
one, tell her that it leads to a contempt. It's a clear violation of the order of the court. That too, it's a compromise. It is where it's a consented order. She has asked everything, right from, I asked her, what do you want? Yes, 2, 3, 4. Everything was for her requirement. This is done. Now, I think she should, all this shows that part of the order where the court says she remember that he has to pay the extracurricular activities, fees for all.
No, I do not know. These are the one-sided submission
But
that I do not know.
what
I
does
do not know
that-
anything about
No,
that.
he's receiving, she's
I will,
receiving it.
I will take instructions.
So when she says he should pay the EMI, then I have directed them to pay the EMI, he's paying the EMI. So when part of the order she remembers, I think she should also remember the first order. This kind of conduct, the court cannot appreciate.
No, that's true, my lords, but kindly permit me to,
What I want is,
Please.
without this order being uploaded,
please.
17/8/2024 to 19/8/2024, she has to come to Bangalore. She didn't come to Bangalore. Now, on 26th is a holiday. Now you have Saturday, Sunday and Monday, or else if she comes on a
Thursday, Sunday is first time, she can come on Thursday.
comes on Saturday, if she comes on Saturday, Friday is holiday, and it's not a holiday Friday.
No, not at.
Saturday, if she comes on a
But
Saturday,
Saturday means Friday, the flight comes only 8 o'clock in the night, then she gets only Sun gets only 1 day. She comes on Friday evening,
Friday, but what time is the flight there?
5 o'clock from Gwalior to Bangalore, after school.
So if she comes on Friday, Saturday, Sunday, I think Monday she can go. Tuesday is about.
Monday early. 5
I will have to-
o'clock, 5 o'clock.
I will also check with the child. Now, it's one instruction is the very intention because one application was filed there initially. Now, my lords, it was dismissed. Now, repeatedly, she is being harassed with all these things. These orders, we are bound to obey my lord's orders. I do not know the text of the order because kindly excuse me one thing.
No.
I was not present because your lordship made a endeavor, my lord,
Yes.
spending lot of
And,
time. But all those things,
absolutely, there is no harassment for her. Everything was comfortable.
please,
And this is not expected from her. Not expected from her.
that
Tell her,
she has
please
not,
ask her, as it is, this order will be uploaded with that change in the order with regard to the date on which she's going to come. If you just get instructions on that, will that clause number 4 with regard to the date, instead of 17/8/2024 to 19/8/2024. Now, whatever she says, Friday, Saturday, Sunday, 3 days, when is it convenient to her? If she says, this order is final,
with only change in the date.
only the date, please get instructions.
Your lordship, call it 2:30,
2:30,
please,
so that we'll pass an order.
please.
Yes.
Sir. Okay, for the petitioner.
Huh.
Senior counsel is engaged in this matter. Today has some inconvenience. Will it be accommodated in the next week minutes?
Yesterday also, I think you were not there.
No, so evening minutes, I got held up with. Yesterday up to 6 PM, I stayed in court hall 23 minutes. I had one matter there. In fact, there is a memo is also filed. Anyway, lordship may take this matter next week notes because the executing court, the date is given on 23rd. I will take this, if this case is taken on 27th minutes.
What is the difficulty to argue today?
Senior counsel, some inconvenience. Not. We had engaged.
To engage in senior counsel in this. What is the matter about?
This matter is very simple. There is a decree directing me to produce a general power of attorney said to have been executed by the plaintiff. I was a defendant in this case, their husband and wife. Not, it is my specific case that this document is in the custody of the bank. Not, there is a orders passed by the trial court also directing the bank official to produce the document. But subsequently, there is some change in the manager. He comes and says, I don't have any knowledge. Not now.
There is a question of knowledge.
The manager says so, but the court records are finding that the document is in custody of the bank. But in the order, not CH-29, the trial court passes a specific order. Bank has to produce the document. It is in the custody of the bank. In the final order, there is no specific finding by the trial court.
That
Para
Like,
21 and
issue
25.
is such a simple issue. Why?
But it's not simple. What has happened? Para 21 and 25, the trial court judgment, there is no specific finding, but court says there is no material to hold that document is either in the custody of you or in the custody of the bank. Now, difficulty is appeal is pending before the division bench. Now, in the execution court, the plaintiff has precipitated the issue, and now, my lords, in that, my lord, I filed an application once again with the supporting documents to summon the bank to produce the document so that decree could be enforced. Court rejects that application. The document is not within my custody. How can I produce it? That's my difficulty. Now, another issue is the appeal is already pending consideration.
What are the, you can't even ask a bank that, what
But
are the documents you have
Yes,
filed?
that is what
You have
specifically.
mortgaged the,
Yes, I have taken a loan.
uh,
I've taken a
how
loan.
can bank come with the license? Tomorrow they'll not give you your documents. What will
No,
you do?
let them come and say before the executing court. That is what, no, I filed an application. Executing court ought to have
Order, please
admitted.
come to the order.
No, sir, file is not with me. That is a difficulty. I gave it to my senior to appear through VC, but yes, some difficulty.
When do you want?
Not 27th, my lords, because before the executing court, it's on 23rd. And there is continuous holiday. I will take chance on 27th.
Hold this matter on 2nd of September.
Please.
Yes.
My lordship, if I may allowed to make a submission with regarding to the case, the bankers were called for 3 times before the trial court, and the trial court has gone.
We'll decide it on 2nd September. Yes.
Much obliged.
Yes.
Represent the petitioner in this matter, my lords.
Yes.
PM for the respondent.
Sorry? Please.
What is that? No, that is not the case. You're
I was also
confusing.
surprised, my
That's
lords.
before case. Sir.
That is for the earlier matter. Represent the petitioner again.
The respondent.
Please come. Agreed with orders passed on 15/3/2024. The this court on 15/3/2024 has passed an order with the following conditions, that is page 125. And after this order is passed, the wife left the country along the
23, March 20.
15/3, I think.
No, ma, 23. 20th of March.
The date of order, this one it appears to 15/3.
28/3 months. 28/3, large for para number 15.
Huh.
By order.
23/2024, wherein this court has passed the order with the following, when is the matter coming up before the Supreme Court?
No such date. No.
September second week, I'm told, my lords. I'm
It's
not
not-
sure.
September,
Second week, I'm told.
the stay expires.
May I just pass that order, my lords?
Huh?
Till further year.
Huh?
Until further year.
No, for a period of 6 weeks, that's what it says.
But my lords, on 26th, the child's school will reopen in Dubai.
I think you're not understanding what the court is asking. You're only submitting something what you want to submit. I said, what is the Supreme Court order? I said,
They have stayed only para number 15 clause 3 and 4, my lords. That restraining the child to bring back to India, my lords. I've produced the copy.
Then your client will not approach Supreme Court. He will only wait till. Then wakalat and what steps, application to vacate that should be filed by you? Where is that order? It is only for 6 weeks.
My lords, the order reads like this, my lords. Issue notice returnable in 6 weeks. And the order of this honorable court dated 20th of March 24, as well as in paragraph 15, Roman 3 and 4, are stayed till the next date of listing.
Now, where are those papers that are filed before the Honorable Apex Court?
Lords, I have not produced it, lords.
Please produce it.
I will produce it.
And also, we will also now record
Please, lords.
with regard to this clause number 4, she has complied with even before going to the Supreme Court.
Yes, my lords. My understanding is correct.
Then why this order, this particular, which is already done, was not brought to the notice of
I
the
can
court?
only plead ignorance, my lords, because I am not privy to what has happened before the honorable apex court. My lords may have it
Only
tomorrow.
thing- No.
I
Only
understand,
thing-
lords.
Only thing why this court is hesitating to pass an order is, it's only the judicial discipline. Now this fourth, which she is already complied with.
Yes,
That is not brought to the notice of the Supreme Court.
I'm not aware, my lords. Let me not make a submission.
If it is
May
brought
I
to the-
make this request, my lords?
No, if it is brought to the notice of the Supreme Court, why would it stay?
I totally, I'm understanding what my lords are indicating, lords. Could it be at tomorrow or day after so that I can get the papers and place it before my
What will
lords?
happen is, now here, if you read it, the mother, the other day, because it is already complied with, I thought of passing an order. Then again, if you read it, the mother shall send email to the school in Bangalore at the earliest stating that for the next academic year, the child will join the school and the payment of fees and other formalities, the father will complete. The Supreme Court had granted a stay on a order, which is already, it is already worked out.
Please, my lords. So there's no point in actually, I'm with my
No,
lords.
if it cannot be, if you don't look at it, then nothing can stop.
That's the
this
reason I
court,
made this request.
No,
My
no,
lords may
nothing
have
can
it.
stop this court from passing the order. So the problem is, when it is not brought to the notice of the court, when that particular thing is stayed, and without clarifying that, if the court proceeds it, then if the girl can't be joined in a school, question of looking at the interest of the girl, why should the girl come to India?
Please.
Isn't it?
Yes, my lords.
Then how can that order be passed?
That's the reason I have also not gone through the petition as such. My lords may have it tomorrow or day after, so that I'll request the client to get me from the counsel, whoever is appearing on behalf of her. I'll place it before my lords, so that at least I will also have the benefit of assisting this court in so far as what is being stated in the honorable apex court. Day after, my lords, Wednesday, my lords, and Thursday, my lords may have it. By then I will get a copy.
We posted tomorrow, my lord, because on 26th in Dubai, the child school has been reopening, my lords. And in
No,
order-
please understand. From how many days, why are you waiting here? Why didn't you go to the Supreme Court and move the court?
My lords, on 8th we have filed the wakalat.
If at all, if they have been served with the copy, my lords, it would be helpful if they can.
Have the copy?
I've produced the copy.
Copy of what?
Orders, my lord, Supreme Court orders.
Yes. Unless and until that particular,
I understand, my lords. I will also go through it, my lords, once I get the papers. I'll place it before my lords so that I'll assist the court in whatever.
yes, pose this
Oblige.
matter on Thursday.
Oblige.
Yes, give that.
One week time may be granted.
Huh?
1 week time may be.
No. Pose this matter tomorrow. If the further adjournment is sought, it's an MFA of 2014. Same would be dismissed on that ground. Yes,
Pass out the matter.
tomorrow. That's all. Little back. Yes.
There are 3 appeals
Yes,
of the same procedure.
it has come up earlier.
My lord, yes, it was.
That day, like someone, what ground it was adjourned?
My lord, I was not here when the matter was called.
Yes,
I was not here.
yes. Now, what are these appeals?
Lord, suit is one for specific performance of an agreement of sale. The agreement of sale, I will just narrate a
Yes,
few.
yes. Yes.
8/7/2021 is the receipt or agreement of sale. Madam. It's an agreement of sale as per, as 8/7/2021. The sale consideration is 90 lakhs,
19 lakhs.
90. The advance paid is 10,000.
Yes,
The time agreed was 6 months,
advance paid is
10,000.
Yes,
The total time agreed is 6 months from 8/7/2021.
yes.
The total extent of the land agreed to be sold by respondent number 1 is 7 acres 77 cents at a place called Mudradi village in the present Hebri Taluk.
Yes.
My lord, then application was filed. Along with the plaintiff, application was filed on 12/9/2022 under Order 39 Rule 1 and 2 to for an order not to alienate, alter, or put up any construction against the defendant.
You are the plaintiff in this
I
one.
am the plaintiff. The another application, IA number 4 was filed by the defendant against the plaintiff.
Yours is IA number?
IA number 2, ma'am.
IA number 4 is by the defendant.
IA number 4 is by the defendant.
What he
Because
says?
that I should not give any paper publication in regard to the sale of the property, agreement of sale, and that the WhatsApp messages shall not be sent in regard to the sale of the property. That is also an application for injunction. That was filed on 4/11/2022.
It was allowed.
That is allowed.
Your petition is dismissed.
My application is dismissed.
Then what about the other one, third one?
Then another is IA number 6 filed by the plaintiff for not to put up the construction, that injunction not to put up the construction.
That's also dismissed.
That is also dismissed.
No, MFA 266 of 2023 arises out of
Out of IA number 2, madam.
2353?
IA number 4
Yes.
and 2416 IA number 6.
No, you have that you are deposited that amount of 90 lakhs before the court while filing that.
No, no. My entire case is that agreement is for 90 lakhs. I have applied for loan and I am ready and willing to pay that amount. Therefore, I am entitled for a suit for specific performance. It is not the case that at the time of filing the suit itself, the entire amount need to be deposited.
Your ready and willingness.
Ready and willingness is shown by sufficient proof that I the appellant's father has a property. This is a village, my lord, every. Appellant's father has a property in Bangalore. He has applied for loan and obtained the legal opinion on what to raise the loan. All that is placed before the court. The suit is pending.
Let's see.
My lord, the applications, my application came to be rejected, both applications. And against that,
Please come to
this
the order.
appeal is fine. And now in the written statement, their contention is
Yes,
that it is 10,000 is too meager a amount. It is a receipt, only a receipt is placed before the court for having paid 10,000. Therefore, this is not an agreement of sale.
Hmm.
On that, court has given a finding that it is an agreement of sale. So therefore, right now, the finding is that there is an agreement of sale. And this honorable court has passed an order of status quo. My lord, kindly permit me to read the order which is impugned. Kindly see page, take page. It starts at page 15. The applications are referred in at paragraph 11. Lord, may kindly come to reasoning at paragraph 17. May I read, my lord? The plaintiff has filed this suit for specific performance of agreement of sale dated 8/7/2021, directing the defendant to execute the sale deed in respect of suit property by receiving balance sale consideration of rupees 89,90,000 according to the plaintiff. The defendant being the absolute owner, having agreed to sell the suit properties for a consideration of rupees 90 lakhs, issued a sum of rupees 10,000 towards a part consideration, and to that effect issued receipt, and that plaintiff has always been ready and willing to perform his part of the contract, but defendant, instead of executing the registered sale deed by receiving balance sale consideration amount, now trying to alienate the suit properties to some third party for higher consideration. If the elements of the written statement is perused, the defendant number one has admitted the receipt of sum of rupees 10,000 from the plaintiff, but categorically contended that the plaintiff has misrepresented the defendant, that he has sufficient funds to purchase the properties and he will purchase the properties immediately. And believing the version of the plaintiff, he has received meager sum of rupees 10,000 and issued receipt. And before signing the receipt, the plaintiff father, the plaintiff and one Keshav Shettigar promised the defendant that they will enter into a proper duly stamped agreement of sale in future date by arranging sufficient funds, and for time being, as token of receipt of rupees 10,000, the defendant was made to sign the receipt. It was much argued by the learned counsel for defendant number one that IA number 2 is infructuous because the defendant has already sold the suit properties, that the receipt alleged agreement of sale does not bear the signature of the plaintiff, and plaintiff has not accepted the proposal offer, and that the alleged receipt agreement is not duly stamped, and that all the suit properties are not mentioned in the alleged document, and that plaintiff at no point of time had come forward to get the sale deed executed by pay balance consideration amount, which constrained the defendant number one to sell the suit properties. My lord, all the properties are not sold. Portions of the property I shall refer to it. Referring the document dated 8/7/2021, the nomenclature of which is agreement. It is vehemently argued by the learned counsel for the plaintiff that the agreement between the plaintiff and defendant is oral one, and that defendant having agreed to execute the registered sale deed for a total consideration of rupees 90 lakhs and having received advance amount of rupees 10,000, executed receipt dated 8/7/2021, and that defendant has admitted the receipt of a sum of rupees 10,000, and that in pursuance of the agreement of sale, the plaintiff has raised a loan to arrange the balance sale consideration, and balance amount was ready with the plaintiff, and that though the defendant has contended that he has returned the advance amount of rupees 10,000 and thereby cancelled the transaction, but nowhere he has stated the date on which he has repaid the said amount and cancelled the document. And defendant number one has not produced any document to show that he has repaid the said amount, and that if really defendant had repaid the said amount, then he would have received the receipt to that effect from the plaintiff, and that even though said agreement does not bear the signature of the plaintiff, but it is not mandatory that both parties should sign the document, and that the plaintiff has made all the arrangement for payment of balance consideration amount by applying loan, and that he was ready with the balance consideration amount, and that the defendant having not executed sale deed, when plaintiff issued legal notice, intentionally refused to acknowledge the notice, and the very refusal on the part of the plaintiff to receive the notice itself indicates that he is not ready to execute the sale deed. And that in case of immovable property, time is not the essence of the contract. And that even if plaintiff has paid only a meager amount, but as per amendment to specific relief act, specific enforcement is the rule and denial is exception. And there is no discretion left with the court to order otherwise than the specific performance of contract, and that defendant number one, in order to defeat the right of the plaintiff, has sold portion of the suit properties during the pendency of the suit without obtaining the leave of the court. Hence, rule of lis pendens would apply, and purchaser cannot take the contention that they are the bona fide purchasers of the suit properties. In support of the argument, the learned counsel for the plaintiff at this juncture has placed a RTC extract pertaining to the suit property which stands in the name of defendant number one. The sale deed executed in favor of defendant number one, receipt alleged agreement of sale allegedly executed by defendant number one, legal opinion obtained by the father of the plaintiff in respect of the property belonged to the father of the plaintiff, the legal notice got issued to the defendant, etc. Regarding admissibility of unstamped document and impounding of unstamped document is concerned, the learned counsel for the plaintiff referred while ruling reported in 1969 Mysore Law Journal 299, wherein it is held that when a document comes before the court for the purpose of being used in evidence, the jurisdiction of determining the duty and penalty for the court arises. In 1994 Karnataka 3143, it was held that the exercise of jurisdiction under section 34 arises where a document is actually tendered in evidence even if the document is produced earlier. ILR 2010 Karnataka 5156, it was held that merely because documents are produced along with the plaintiff, that by itself does not warrant for impounding of document. On the point whether the time is the essence of the contract or not, in case agreement relating to immovable properties, the learned counsel has referred the ruling reported in AR 1967 Supreme Court 868, wherein it is observed that fixing the period of sale deed does not make time the essence of the contract. Regarding the legality of the document signed by only one of the parties concerned, more particularly in case of agreement of sales signed only by the proposed vendor and not signed by the proposed vendee is concerned, in a ruling reported in 2009, 2 SCC 582, it was held that agreement signed by one of the parties evidencing oral agreement is valid in India. Even the sale deed signed by the vendor is valid. Regarding purchase of portion of the suit properties during the pendency of the suit is concerned, the learned counsel for the plaintiff has referred ruling reported in ILR 2010 Karnataka 629. It was held that sale done without the leave of the court during the pendency, the plea of bona fide purchase does not arise. 2007 to KCCR 1482, whether the contract is vitiated by fraud, etc., should be decided only in a suit. Only prima facie case for grant of injunction has to be considered. If the pleadings, the argument advanced by the learned respective counsels and the documents produced by the respective parties is perused, it is not in dispute that the defendant was the absolute owner of the suit property by virtue of the registered sale deed dated 6/12/2007, executed in his favor by one Krishna Shetty, and now he is the absolute owner of the portion of the suit properties. If the version of the defendant number one is perused, no agreement of sale was entered into between him and the plaintiff, but only negotiation was held to sell the property, and meager sum of rupees 10,000 was paid by plaintiff as token sale negotiation, promising that plaintiff will enter into duly stamped agreement of sale by paying part consideration of rupees 25 lakhs. But plaintiff has not come forward to enter into an agreement of sale or to purchase the suit property within the time stipulated time by tendering balance consideration amount. In order to specific performance enforcement of contract, there must be either oral or written agreement between the parties. At this stage, plaintiff has produced the document dated 8/7/2021. It is bent upon argued by the learned counsel for the plaintiff that the document placed on record is mere receipt, acknowledging the receipt of rupees 10,000 by the defendant and the agreement entered into between the parties as an oral agreement. But if the entire averments of the plaintiff is perused, nowhere the plaintiff has pleaded that there was oral agreement entered into between him and the defendant. In para number 6 of the plaintiff has sought the relief to the effect of specific enforcement of agreement of sale dated 8/7/2021. If the notification given by the plaintiff in Vijay Karnataka daily newspaper dated 27/9/22 is perused, wherein it is stated by the plaintiff that there was written agreement dated 8/7/2021 entered into between him and the defendant number 1, and thereby contended that the document which is before the court is the agreement of sale. If the document dated 8/7/2021 is read in whole, the nomenclature and contents of the document is somewhat in the form of agreement of sale. The defendant number 1 admits the receipt of rupees 10,000 and the receipt issued by him acknowledging the receipt of rupees 10,000, but contends that since the plaintiff has not come forward either to enter into duly stamped agreement of sale by paying consideration amount or to purchase the property by paying balance consideration amount, he has cancelled the said agreement by returning the amount of rupees 10,000. The plaintiff
Yes.
The plaintiff at one breath contends that it is an agreement of sale and another breath contends that it is receipt. But whatever may be the nature of said document, but one thing is clear that it is not duly stamped. If it is an agreement of sale where the possession of the property is not delivered, then the plaintiff has to pay stamp duty and penalty over the consideration amount at the rate of 0.1%. And if it is receipt, then also on rupees 10,000, the plaintiff has to pay stamp duty. Section 223 of the Indian stamp mandates for affixing of a revenue stamp on any receipt above rupees 5,000. Though the learned counsel for the plaintiff, by referring to judgments referred above, submitted that merely because documents are produced along with the plaintiff, that by itself does not warrant for impounding of document. But in the ruling relied upon by the counsel for defendant number 1 and defendant number 2, 2 to 6, reported in ILR 2003 Karnataka 879 between so and so, wherein it is observed, section 33 and 34. Document not duly stamped, agreement to sell, whether courts can refuse to grant injunction, held that the document in question and agreement to sell not duly stamped as per the relevant provisions of the Karnataka Stamp Act 57, and therefore the court has power to refuse injunction. Section 34 stipulates a specific prohibition against instruments capable of with the duty being admitted in evidence for any purpose whatsoever. Any instrument relied upon by any litigant before a court is required to be stamped under the provisions of the Act, and so long as that instrument remains unstamped, Section 34 forbids its user for any purpose whatsoever by the court, authority or person competent to receive evidence. The court has got powers and would therefore be entitled to impound the instrument in exercise of its power under Section 33 of the Act. Meaning of words for any purpose, the expression for any purpose appearing in Section 34 is wide enough to include within its amplitude use of the document for the purpose of performance or similar other reliefs. There is nothing in Section 34 of the Stamp Act that an unstamped or an understamped document can be made use of for the purpose of issue of an injunction or for grant of any other interlocutory order. further 2010 Supreme Karnataka, so and so between it was held, referring to Order 13, Rule 8 of the Karnataka Stamp Act and Section 34 and 37, that Order 13 Rule 8 specifically provides for impounding a document or document produced before it for sufficient reason on such terms as the court may direct. It cannot be said that it is only such documents as are produced and sought to be admitted in evidence that can be impounded, if not duly stamped or for such other reason. In other words, the court can impound a document in the very first instance that it is produced before the court in terms of Section 34 of the Stamp Act. The moment it comes to the attention of the court that a document produced in a suit is not duly stamped with duty chargeable, the court shall impound the same. In the said case, reference was made even of ILR 2010 Karnataka 5156, which is the ruling relied upon by the plaintiff, and observed that the said cases does not accord with the ration of the decision of the apex court in Peteri Subbarav's case, nor does it accord with the provisions of the Stamp Act, which should be rendered unworkable. From the observations made in the above said ruling, it can be said that unless and until deficit stamp duty and penalty is paid, such unstamped document cannot be looked into for any purpose, even for considering the temporary injunction application. And such document, till it is duly stamped, is inadmissible in evidence when the whole case of plaintiff revolves around the unstamped document dated 8/7/2021, and when the plaintiff claims the relief of temporary injunction
Where
on
is
the.
that agreement of sale?
Yes, Mila, I'll place. It is a receipt which the court has given a finding that it is in the nature of agreement of sale. My lord, may I place it on record?
Please take it.
It is in Kannada. It translates. Lord, may I read that English translation?
So as per this, within 6 months from the date of agreement, you have to pay the remaining 89 lakhs and
Yes,
get the agreement
yes.
registered.
And
So when is this date of
date of agreement is 8/7/2021, my lord.
8/7?
2000,
Hmm. Yes.
2021.
Hmm. When did you issue the legal notice?
Legal notice, my lord. 13/8/2022.
38?
13. 13/8/2022.
That is almost after a year.
Yes, and before that,
At 6 months, what did you do?
my lord, 6 months, I had applied for, my father had applied for a loan, and on that, the bank had asked for legal opinion on a title of my father's property situated at Bangalore. My lord, there is a pleading to that effect. I have placed the plaint before the court. Kindly see the plaint.
When did you make the application for the loan for your property? That's observation of the court.
My lord.
What is it placed before the court to say that you have applied for the loan?
My lord, I have requested my father raised the loan for my purpose. Kindly see the plaint at clause C, my lord, page 3.
Before we go to the plaint, please
Please.
once again come back to the order impugned.
Yes.
Page 39.
Yes, madam. line about third, Mala.
39, internal page 25. Further, if the recitals of the
Further,
document.
if the recitals of the document dated 8/7/2021 is perused, the period stipulated for execution of the sale deed by receiving balance sale consideration amount was within 6 months from the said date. Admittedly, plaintiff has paid only sum of rupees 10,000, which is very nominal amount when compared to the total consideration amount. Though the plaintiff, by producing legal opinion, has contended that soon after the execution of the agreement to adjust the balance sale consideration amount, they have applied for loan and he is ready with the balance consideration amount. But if legal opinion which is before the court is perused, it is obtained in the name of the father of the plaintiff, and property in respect of which legal opinion is sought is the property of the father of the plaintiff, but not of the plaintiff. Further, the legal opinion alleged to have been obtained on 16/7/21, but plaintiff has not placed any document at this stage to prove that either he or his father, subsequent to the legal opinion, have applied for loan and got sanctioned loan in their favor. If really plaintiff is ready with the money to pay the balance scale consideration amount, then he could have produced the loan documents and loan sanction document instead of producing only legal opinion copy. When plaintiff has paid paltry sum of money and he has to arrange for huge sum of money, and he has to prove that he is ready and willing to perform his part of the contract, but defendant has not come forward to perform his part of the contract. If the aforesaid document is perused, there is no obligation casted upon the defendant to perform except to execute the sale deed by receiving balance consideration amount, but obligation is casted solely upon the plaintiff to tender the balance consideration amount in time and to get the sale deed executed in his name. But as observed supra, though the time stipulated in the said document is within 6 months from the date of said document, and a period of 6 months is reckoned from the date of said document, then period of 6 months expires on 8/1/2022, but it is on 13/8/2022, the plaintiff has issued a legal notice to the defendant calling upon him to execute the registered sale deed. When plaintiff has given only nominal sum towards the part sale consideration, he cannot expect the defendant number 1 to wait for years together for the balance amount by keeping the properties intact without putting the valuable properties into deed. Had it been the case that plaintiff has paid major portion of the sale consideration, my lord, kindly note this. Had it been the case that the plaintiff has paid major portion of the sale consideration amount, there is a small amount to be paid towards the balance consideration. Under such circumstances, then, when defendant has the scope for enjoyment of the part consideration amount received by him, then there is every reason for the defendant to wait at least for reasonable time. My lord, the court has come to the conclusion that it is an agreement of sale. Yeah, when there is an agreement of sale and it is agreed, it is for the plaintiff to raise the money. He has made all the efforts, and kindly see paragraph.
Yeah,
C.
as on filing of the day on which you filed the suit.
Yes.
What the loan amount?
My lord, he had applied for the loan. It was not sanctioned yet. It was not sanctioned yet. But my respectful submission is the person an agreement holder need to prove that he has the ability to pay the amount. He need not show the amount to the court, but he should prove that he has the ability to raise the amount. That pleading is before the court. Now, why the court rejected the application on 2 counts? One is, time is the essence of the contract. Because you agreed to pay the balance in 6 months. You have not paid.
Yes.
That is one thing. Second is that only a portion of the amount is paid. Agreement of sale is admitted, or the court considers that it is an agreement of sale. A portion of the amount is only paid. Look at the amount consideration is 90 lakhs and then only 10,000 is paid. Therefore, we cannot give you an order of injunction. My respectful submission is, well, once there is a contract to sell, it is not the consideration amount, what is paid is to be considered. Not even without payment, if there is a contract, then that contract need to be honored is my respectful submission. My lord, to that, I would like to refer to section 2H of the contract.
No, that for that, no judgment is required. No
Yes,
provision is
because
required. Yes, we'll
and
take your submission.
2H says an agreement. Please permit me to read. It is not the amount, it is an agreement which is to be honored.
Yes.
Section 2E.
Yes.
Section 2E.
Yes.
Every promise and every set of promises forming the consideration for each other is an agreement. Then kindly come to H.
Yes.
An agreement enforceable by law is a contract. My respectful submission is, there is an agreement in place. That such an agreement is, it is not hit by section 23 of the Contract Act. It can be enforced by law. Therefore, that ought to have been honored. The trial court proceeds on the basis that that agreement cannot be looked into at all. It has come to the conclusion that it is an agreement of sale.
By the time you file this application, the subsequent purchasers are parties to the suit?
Yes, madam. Yes, because that they had purchased the property, respondent, defendant number 2 purchased a portion of it on 6/9/2022. Portion of it, about 29 cents.
Yes.
And another portion of it, 71 cents, also purchased under the same sale deed. Then 35 cents was purchased by defendant number 3 on 26/9/22, my lord. And defendant 5 and 6, they purchased 3 cents and 7 cents on 26/9/22. All these total purchase, the total extent of the land purchased by them is 2 acre 93 cents.
31 of the order is detailed.
Yes.
2 acre 93 cents out of 7 acre 77 cents. My lord, I have also taken a contention that it is hit by lease pendants. They are not bona fide purchasers. Or if at all they were to purchase the property, they
When
should.
did you institute the suit?
My lord, that is on
12/9/22.
12/9/2022.
22. And
Yes.
the sale deeds are?
Sale deeds, the 2 sale deeds, my lord, are on 6/9/22.
That is much before your suit.
My, yes.
Mhm.
On, then 2 sale deeds were on 26/9/22. My notice, my lord, the defendant had the notice on 13/8/2022.
No, summons.
Oh,
From the
my
court.
legal
No,
notice.
that I
was-
understand.
Yes.
When he received the summons?
Summons, we have to find out, my lord. I shall let. So, therefore, as on the date of filing suit, the defendant had the knowledge. I had issued notice calling upon him to sell the property to me. I have shown my bona fides, and the court also says that it is an agreement of sale. No doubt. On that, there is no counter.
Yes.
Then, therefore, my lord, kindly see the order, the fine order. Paragraph 35 for a minute, because there is.
I have read the entire order. You can make your submission.
Lord, IA number 4, my lord, order on IA number 4,
I've seen the entire order. You can make your submissions on that.
please.
Yes.
My respectful submission is on IA number 4. I am the agreement holder. I have certain rights over this property because of the agreement. And I can give publication WhatsApp message. Yes, I have entered into an agreement of sale. I am going to purchase this property, and buyers be aware of this. I don't think any unreasonableness in making such a publication. Court has restrained me from sending WhatsApp messages on all that on the application. On this, my lord, the two submissions, my lord. One is in respect of immovable properties, time is never the essence of the contract. Section 55 of the Contract Act. I would like to place two judgments before the court.
Pass on both the judgments.
Hello.
You said you're relying on two judgments.
Both the
pass.
judgments are there.
Yes. Yes.
One is
Yes.
2008
Yes.
4 SCC 464. That judgment relies on Chandrani's case, 1993 Supreme Court, my lord. Paragraph 10 may kindly be seen at
Yes.
ink page 4. In Chandrani versus Kamal Rani, a constitution bench of this court has held that in the sale of immovable property, time is not the essence of the contract. It is worthwhile to refer the following conclusion. It is a well-accepted principle that in the case of sale of immovable property, time is never regarded as the essence of the contract. In fact, there is a presumption against time being the essence of the contract. Then please turn to the next page, my lord, at paragraph 11. The court refers to two other judgments, then para 11. It is clear that in the case of sale of immovable property, there is no presumption as to time being the essence of the contract. Even where the parties have expressly provided time is of the essence of the contract, such a stipulation will have to be read along with the other provisions of the contract. Then paragraph 12. This court in Swarnam Ramachandran versus Aravakod Chatungal Jayapalan has once again reiterated that time is not the essence of the contract relating to immovable property. That time is presumed not to be the essence of the contract relating to immovable property, but it is of essence in contracts of reconveyance or renewal lease. The onus to plead and prove that time was the essence of the contract is on the person alleging it, thus giving an opportunity to the other side to adduce rebuttal evidence that time is not of essence, that when plaintiff pleads that time was not of essence and the defendant does not deny it by evidence, the court is bound to accept the plea of plaintiff in cases where notice is given making time of the essence. It is duty of the court to examine the real intention of the party giving such notice by looking at the facts and circumstances of the case, that a vendor has no right to make time of essence unless he is as ready and willing to proceed to completion. And secondly, when the vendor purposed to make time of the essence, the purchaser must be guilty of such gross default as to entitle the vendor to rescind the contract. My lord, suppose we say that 6 months, time is the essence. The vendor ought to have issued notice. Look here, the time was fixed for you to pay the balance sale consideration. You are not paid it. If you don't tender that amount within a period stipulated, then I am going to sell the property. Or the contract no longer survives. There is no such notice at all. till I issue a notice, then he comes and says that, then he has sold the properties. 2 items were sold subsequent to the filing of the suit. And all the 4 items, small portions of the items, after the issuance of legal notice. My lord, kindly come to the next citation, that is AR 1967, Supreme Court 868.
Yes.
My lord, paragraph 3, Supreme Court poses the question. This para 3 at page 10. In this appeal, with a special leave, 2 questions fall to be determined. Whether under the agreement of sale, time is hours of the offense, whether as alleged by appellants 1, 2, 3, respondent was not ready and willing to perform his part of the contract and was on that account entitled to a decree specific performance. The facts which have material bearing question have already been set out. Section 55 of the Contract Act, which deals with the consequences of failure to perform an executory contract at or before the stipulated time, provides by the first paragraph. When a party to the contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before the specified time, the contract or so much of it has not been performed becomes voidable at the option of the promisee if the intention of the parties was that time should be the essence of the contract. My lord, it is not merely because of specification of time at or before which the thing to be done under the contract is promised to be done, and default in compliance therewith, that the other party may avoid the contract. Such an option arises only if it is intended by the parties that time is of the essence of the contract. Intention to make time of the essence, if expressed in writing, must be in language which is unmistakable. It may also be inferred from the nature of the property agreed to be sold, conduct of the parties, and the surrounding circumstances at or before the contract. Specific performance of contract would ordinarily be granted, notwithstanding default in carrying out the contract within the specified period. If, having regard to the expressed stipulations of the parties, nature of the property, and the surrounding circumstances, it is not inequitable to grant the relief. If the contract relates to sale of immovable property, it would normally be presumed that time was not the essence of the contract. Lord, I will not quote much with this, only one. My lord, kindly come to page 9, ink page 19.
Yes.
Bottom of it, last but 4th line.
Yes.
So, my lord, ink page 19, left hand side, last but 4 line. As the time was not of the essence of the contract, it was the duty of the appellants to give to the respondent a notice fixing a reasonable time for the completion of the sale. My lord, here they have not issued. They have not called upon the plaintiff to pay the balance consideration. Of course, there is the plaintiff has to pay the amount. The question is whether time is of the essence, because the trial court proceeds on the basis time is the essence of the contract. Therefore, you are not entitled for an order of injunction. My lord, I have sought what I have sought. Let them not to alienate the property till the disposal of the suit. I say that I will make the payment. The case is not gone on for trial. It is at the initial stage. All this is to be tried. And one more submission, if the court permit, there is already an order of status quo by this honorable court. If that is retained, only order of status, that also court may.
But I am for the respondent number 2 to 6 minutes who are the purchaser. But defined number 2 and 4 will not purchase the property measuring 1 acre and by defined number 4, and 29 cents and 71 cents notes by the defined number 4, 2, prior to institution of the suit, not without having any knowledge about the execution of either receipt or agreement, whatever it may be, and not filing issuance of legal notice, because legal notice has not been served on the first defendant who alleged to have been agreed to sell the property.
Lord, define number 356, Lord, have purchased the portions of property on 26/9/2022. Lord, the first defendant, Lord, though admitted that he received a sum of rupees 10,000, the amount is very, very meager. Plaintiff cannot, Lord, prevent or lock the landowner from exercising his right to either alienate or Lord, whatever he wants to do, Lord, by paying a peanut amount. Therefore, Lord, the trial court, Lord, has rightly observed that when the alleged receipt or agreement of sale is not duly stamped, therefore, the very agreement cannot be looked into. And as such, Lord, the suit itself is not maintainable. And when the suit is not maintainable, the question of granting interim order, Lord, may not be.
No, that's not the finding.
But what I have contended before the trial court, that Lord, the agreement is unenforceable.
But that's
It is
not the
not
finding of the
duly
court.
stamped. That was my argument before the trial court. Therefore, Lord, I have made such a submission that when the Lord, when the plaintiff has paid a small amount out of 90 lakhs, only 10,000 has been paid as admitted by the first defendant. He cannot prevent the first defendant from exercising his ownership right. On the other hand, Lord, we being the purchasers, Lord, one of the defendant has already put up construction. Defendant number 3, Lord. He can't restrain the other defendants from putting up constructions, having invested the money on the property.
What is the nature of constructions and what are they?
But one house is constructed by the defendant number 3, Lord, in his property. And there is no other construction, not because it is an agriculture land. Lord, one of the defendant, Lord, has raised a compound wall to protect the Lord, trespass by wild animals.
No, what if not to further alienate? Pending the suit, that would be the not the status quo. Let there not be an alienation. That can be done.
And for the first defendant, my lord, in fact, my lord, in the plaint itself, he was not sure, my lord, whether it is a receipt or agreement. But my learned friend said, my lord, the court has come to the conclusion that it is a sale agreement, but that is wrong, my lord. It has not reached that stage also.
No, but the court has given one finding that it can be, you cannot deny.
Even if it is considered as agreement,
Now the issue
then he
is-
has not,
now the
please.
issue is, court has to still deal with it, whether the time is the essence of the contract or not, whether there is an agreement or not, whether it is enforceable or not. No, what is the purpose of passing an interim?
But in fact, my lord,
order?
it has gone beyond.
that's-
Detail is so.
It has been, no,
Please,
the subsequent.
Trial court has to justify his order,
No, no,
its order. That is why
subsequent,
he might have
purchases,
ventured into those.
are
But
already-
otherwise, my lord, even para 30 of the judgment order, it has been, because only 90,000, 90 lakh is the fair sale consideration. It is not disputed. And only 10,000, whether he is taking undue advantage of the situation or is a question, my lord. And whether he is a bona fide agreement holder, even if it is considered as a agreement. But he himself is not sure.
No.
In the plaint itself, he said, it is a receipt.
Again, this property is sold out.
Placement.
Again, third party.
Some
guys
portion.
say, "Why unnecessarily all this? Don't do whatever you want to do with the property, don't sell it."
But whether he can ask for restraint by paying only 10,000, that is the only question. That too, my lord, unstamped. See, but legal position is very clear, my lord. He has to do something. Maybe so far as this readiness, willingness, even though he has issued a notice, my lord, he has not said, my lord, whether
No, during the course of the trial.
even whether that document can be looked into is a question.
Understand.
Please, ma'am.
During the course of the trial, if the court comes to the finding that the agreement of sale that is executed is an
Maybe
enforceable one,
even if you ignore that portion, my lord,
entitled for it. No, if it changes 3-4 hands, what should happen?
but whether he can restrain by paying only 10,000, that too unstamped receipt or agreement.
Take 10,000.
That is the only point, my lord.
Why did you take 10,000?
No, my
For a property of 90 lakhs, why did you take 10,000 and why did you give an agreement? You admitted that you have taken 10,000.
no, my case was, my lord, I have paid back, but for that there is no.
Evidence for that. Yes, please come.
Moreover, my lords, except, my lord, the legal opinion, he has not produced any document to show that he has applied
So
for loan.
what is from your side is, when you have entered into an agreement,
My limited.
you should have said, defendant ought to have said that, as per the so and so, within 6 months is, as per that you have to do, as you have not done it, I'm going ahead with my transaction. Should have been.
Maybe, my lord, but the amount was so meager,
What to
they
do?
might not have taken serious.
You are the person who is very much interested to sign on a paper for
That is
90
there.
lakhs, and which you admit, that's a whole issue. You admit, you never say that I have not signed it. It's an agreement, is an agreement. Whether he paid 10,000.
But whether he is a bona fide agreement holder is a question.
No, it is.
Because never, my lord, even at the time of, as your lordship put it, my lord, even at the time of filing a case also, he has not shown that there is a.
Contract between two parties, how they agree, whether they agree without money, whether they agree with 10,000 or 10 lakhs, it's all between the parties. You have, having ventured into all this, if you want to cancel it, you should have issued a notice.
But he has to show to the court, my lord, at least, that he is ready and is having some sort of arrangement for.
No, by way of written statement, you said all that you accepted your.
That is there, my lord.
Lord, schedule, your Lakshmi kindly see, my lord, the learned friend, my lord, has produced the plaint also. The schedule, my lords, there are 6 items, 7 items, my lords, in which, my lords, survey number 67 is not involved in the alleged agreement. Whereas, my lords, kindly see English translation. Now, my lord, what my learned friend has produced. The above second para, Divakar Shetty agreeing to sell survey number 66 and 325, measuring 7 acres, 77 cents.
Where do you get this statement?
But the plaint, my lords, what my learned friend, my lord, earlier produced.
No, agreement.
Agreement, my lords, para number 2, my lords.
Survey number 66.
And 325, measuring
7 acres, 77 guntas.
Yes, kindly see the plaint, my lord, schedule. But the 4 items in survey number 66, then 67 is also included. Yes,
How can it be? How can the properties be beyond the?
alleged agreement.
My lord, if the court were to see, it says survey number, maybe the English translate, the Kannada also it is at 325, total 7 acres, 77.
That's what, your
Yes.
survey number is 66 and 325.
66
And
and
325. Then when you come to
320.
the thing, you included 67 or 60.
67.
67
or
also
30.
you included. You included 328. How are they concerned with this, with your agreement of sale?
My lord, the
Only you are concerned with 66.
and 325.
66.
And 320,
That is not at all there.
325. 1 second, my lord, I have a photocopy of this.
This is amended plaint, which is before the court.
That is the plaint is correct, my lord. Whether agreement, I have the Xerox, I'll just see.
The original.
That also to be explained is
No, there are defendants 2 to
6.
2 to 6. Which survey number they purchased?
We have purchased, my lord, in survey number 328.
That
and
is not
66.
that is not the property.
My lord, that is the property, my lord, kindly see.
But 66
The
is
ori-
mentioned.
the Copy
Not
of the
66.
But 328 is not there.
328, my lord, there, my lord, in the receipt, you lost me, kindly see, my lord. Kindly see the receipt, my lord. It is probably, my lord, mistakenly.
Maybe typing mistake.
328. 328.
Instead of
Yes.
it is 66, 325.
My lord, I have the,
No, what I am saying is, in the plaint, it is 328.
Yes, 328.
yes.
My lord, I am the purchaser of a portion of 328.
Then how is he concerned with 328?
328. I have
In-
Yes.
In the handwritten, my lord, it looks like 328, but in the typed, my lord, he has made a mistake. My lord, it is in Kannada, but.
Numbers we can see,
Yes,
328 only,
328,
328 and 66.
yes. While typing, my lord, it had become 325.
But cleverly included 67 also.
67 cannot be.
Cannot be. Who purchased 67?
Not,
They have not purchased 67.
Any of you?
They purchased 328/4 29 cents.
No, why did you include 66 is a
My lord,
question.
this is in the plaint as it is, I have placed it to the court.
No,
My lord.
you means the plaintiff,
Explanation,
why did why
explanation
did the
is not,
plaintiff include 67 when it is not part of the agreement itself?
328 is a part of it and 66 is part of it. 67 is not in the agreement. I need to. But 67, they have not purchased 67.
But what we have intended before the trial court that the very suit itself is not maintainable. Because he wanted to include the property which is not agreed upon. So as to say that total extent is 7 acres, 77 cents.
That is for the trial.
Then how come, then please come to that. No, you are seeking the injunction in respect of the plain scheduled property. Then now where from you will get that 7 acres and all? Please come to the plaint again.
Yes.
Now, when you include 67, then it will become 7.77.
Yes.
Yes, ma'am. True.
So if you delete-
7.77.
if that is deducted from this, what
Then
would be the
it-
amount? What would be the land?
Then it will be
7.05.
7.05 acres, ma'am. Excluding that 67 for explanation for which I don't have. See, if 67 is excluded, it becomes 7 acre 5 cents.
Then that also you can't claim because it has to be as per the agreement.
As per the agreement itself, ma'am.
As per the agreement,
As per
it's
the agree-
7.77.
No, as per the agreement is 7.77. Kind.
Now, how it will become
My
7.77?
lord, kindly give me a day's time. I will get the information on that if it is required, ma'am, if it is required. Because 325.
Boundary mentioned, my lords. Order 7, Rule 3, my lords, provides a specific boundary must be there, my lords, in order to grant an injunction. Otherwise, my lords, the suit fails. But yes,
It is not in dispute, my lord, that there is an agreement. Now these purchasers are raising this.
Not the purchasers, you plaintiff should say that. No, you say that so and so agreement you have entered into with so and so for an extent of 7 acres 77. Then just to give some so and so, that which is not even mentioned in this, in your
My lord,
agreement.
what is 67, I need to say that in the agreement it is not there. I need to, I can get the details on that. The court has not proceeded on that at all, ma'am. Trial court, if the trial court order is to be seen, the trial court has not gone into that aspect. Only two aspects. Time is not the essence of time.
No, it's a specific, the relief of specific performance is not like the.
Right now, my lord, we are at the stage of
Officially relief,
interim order of an injunction.
No, looking at all this, you have to look at the bona fides of the plaintiff also. What is, you don't know which property has to be, you have entered into, pay 10,000 and later you add whatever properties and which are not even there in the agreement. You add them to make that 7 acres, 77 guntas. Please come.
Sorry.
Agreed with the orders passed in. IN number 246 N, OS number 116 of 2022 dated 1st March 2023. The plaintiff is before this court. Against IN number 2, MFA number 2446 of 2023 is filed. Against IN number 4, 2353 of 2023. IN number 6, it's MFA 2416 of 2023. is filed. As these appeals are arising out of out of the same suit, these are disposed of by way of a common order. The plaintiff had filed a suit for specific performance. It is the case of the plaintiff that he has entered into an agreement of sale dated 8/7/2021 with the first defendant for the for the lands in described in a schedule for a consideration of rupees 90 lakhs. And he had paid an amount of rupees 10,000. And as per the said agreement of sale dated 8/7/2021, by paying the remaining sale consideration of 89 lakhs, the defendant has to, the plaintiff has to get the sale deed from the first defendant. It is a case of the plaintiff that he immediately, they have approached the bank and the bank sought for a legal opinion, and the loan transaction is pending, well, that is pending. It is when they came to know that the defendant is going to sell the property, then they have issued a registered legal notice dated 13/8/2022, calling upon the defendant to receive the balance amount, to send a draft copy of the sale deed, and also inform the date of execution. It is the case of the plaintiff that the defendant refused to receive the notice and the same were returned. Then he has come up with the present suit on 12/9/2022. Thereafter, when he came to know that the defendant has executed the sale deed, 4 sale deeds on 26/9/2022 and 26/9/2022, he has impleted them as defendant numbers 2 to 6. It's a case of the plaintiff that the plaintiff is ready and willing to perform as part of the contract, and the defendant had violated the agreement of sale and has executed the sale deeds, and is entitled for the specific performance of the agreement of sale dated 8/7/2021. For that, a written statement is filed by defendant number 1, wherein it is stated that as per the agreement of sale, he has to pay the amount within a period of 6 months from the date of the agreement. And he has also requested the defendant, plaintiff, to pay the amount, and he has failed to pay the said amount. He had sold the property in favor of the defendants.
He has not admitted, my lord, agreement of.
Huh?
It is an unstamped document, that is
No,
receipt.
he has admitted the transaction.
Transaction.
That's what I said, that
Agreement,
there was, no, you're accepting the signature and everything. You
That is
say
there, but
you cannot term it as an agreement of sale according to you. But there is a paper
That
on
is
that,
there.
whatever you now nomenclature you
straight
give,
away I have not admitted that it is.
that what did you write? Pay to pay the said amount, and it is stated that the plaintiff is in the habit of entering into these kind of transactions. And in the same manner, he has done with, in this case, with the defendant also. It is a case of the purchasers that they are the bona fide purchasers, neither the defendant is aware of the pending suit. And they have purchased the property and they have raised certain constructions in the said property. The plaintiff had filed two IAs, IA number
IA number 2, my lord.
IA number 2 is filed.
Not to
Not to
alienate.
alienate.
IA number 2 is filed. Seeking an ad interim injunction, restraining the defendants from alienating, encumbering the plaintiff's scheduled property, or from altering or erecting any structure therein during the pendency of the suit. He had filed IA number 6.
Not to construct.
Restraining the defendants from making any construction of building, structure, or from making any variations in the suit property pending disposal of the suit. The defendant has filed IA number 4. The relief that is sought
Not to trespass and
Page 98, my lord, that paper book.
is the IA number 4 is filed. Seeking a direction to the respondents, restraining them, or to the plaintiff, restraining them from trespassing into the written statement property, giving any paper publication against the defendant, giving any representation to Mudradi, GP, or any other authorities in respect to the written statement scheduled property, or sending any messages through WhatsApp or any other social media matters connecting the defendants and written statement property, or any way interfering with the peaceful possession and enjoyment of the said property by the defendant and the bona fide purchases and pass necessary orders. The trial court, by order impugned, had dismissed IA number 2 and IA number 6 filed by the plaintiff and allowed IA number 4 filed by the defendant. While allowing while dismissing the plaintiff's petition and allowing the defendant's petition, the court had observed that the court had considered about the unstamped agreement of sale. And the several judgments of this court. The court observed that when the whole case of the plaintiff revolves around the unstamped document dated 8/7/2021, and when the plaintiff claims a relief of temporary injunction on the basis of the said document, even if plaintiff submits that he is ready to pay the stamp duty on the document, either considering it as agreement of sale or receipt, but as of now, while considering the application, said document is an unstamped document. Hence, on that count also, plaintiff is not entitled to the relief of temporary injunction. The court has observed that as per the document dated 8/7/2021, the amount has to be paid within 6 months from the date. And he has to pay the balance of sale consideration. The court had considered the legal opinion which is obtained in the name of father of the plaintiff, and property in respect of which legal opinion is sought is a property of the father of the plaintiff, but not of the plaintiff. The legal opinion is obtained on 16/7/2021. The court has observed that the plaintiff has not placed any document to prove that either he or his father, subsequent to the legal opinion, have applied for loan and got sanctioned loan in their favor. If really plaintiff is ready with money to pay the balance consideration amount, then he could have produced the loan documents and loan sanction document instead of producing only legal opinion copy. And particularly when the plaintiff had paid a paltry sum of money and he has to arrange for huge sum of money, he has to prove that he is ready and willing to perform his part of the contract. But defendant has not come forward to perform his part of contract. The court also observed that even as per the document, except to, there is no obligation on the part of the defendant to perform except to execute the sale deed by receiving the balance sale consideration. The court further observes that the 6 months time expires on 13/8/2022. The plaintiff had issued
Expired on 8/1, my lord.
13/8.
13/8 legal notice, 8/1/22. 6 months.
Expires on 8/1/2022. But on 13/8/2022, the plaintiff has issued the legal notice calling upon the defendant to execute the sale deed. The court observes that when the plaintiff has given towards the part sale consideration, he cannot expect the defendant to wait for years together for the balance amount by keeping the properties intact without putting the valuable properties into deal. Had he paid any substantial amount, there is every reason for the defendant to wait. Even the legal notice that is issued to the plaintiff defendant is also after 1 year from the date of the agreement of sale. The court has also considered the fact that the properties were sold by the first defendant in favor of defendants 2 to 6. And that the 2 transactions are before the suit, filing of the suit, and 2 transactions are after filing of the suit. And the court has come to the conclusion that when the defendants 2 to 6 who have purchased the property with their hard-earned money, if an order of temporary injunction is passed against defendant number 2 to 6, they'll suffer substantial injury and hardship when compared to the plaintiff if an order of injunction is refused to grant. And further, the aspect whether the agreement of sale, as the alleged agreement of sale is an agreement of sale is a receipt, the court has given a finding that whether the time is the essence of the contract or whether it is an agreement of sale or a receipt, that will be decided after a full-fledged trial. The court has opined that the plaintiff could not prove his prima facie case, balance of convenience and irreparable loss, and accordingly dismiss the IS filed by him. Then when it comes to the application filed by the defendant, that is I number 4, the court has observed that whatever the transaction held in respect to the suit properties subsequent to the suit is subject to the result of the suit. And the plaintiff is not permitted to make such public notice either in the newspaper or in the social media from a WhatsApp in future till the disposal of the suit. And also observe that the suit property is in possession of the defendant. And there is no justification in the apprehension of the first defendant that plaintiff may interfere with their possession and enjoyment of the properties unless and until the possession is delivered to the plaintiff. He has no right even to interfere with the peaceful possession and enjoyment of the suit properties, and accordingly, I number 4 is allowed. Aggrieved thereby, the plaintiff is before this court. Next paragraph. When the matter came up, when the MFA is at the time of admission, this court has ordered passed an order of status quo when?
My lord, it was on 20th April 2023.
April?
2023.
On April 2023, we'll look at the date.
Which was
On,
continued.
23, and the same is continuing till now. Then counsel appearing for the petitioner plaintiff, appellant plaintiff submits that when there is an agreement of sale and when the time is not essence of the contract, the trial court had when the defendant has agreed that he has taken an amount of rupees 10,000 for the 10,000, and it is agreed upon that the sale consideration is 90 lakhs.
90, please.
90 lakhs. The defendant, without even issuing any notice to the plaintiff, had sold the property in favor of third parties. It is submitted that the trial court has relied more on the fact that it's only 10,000 amount that is given, and the remaining amount that has to be paid is 89 lakhs. As such, there is no prima facie case on behalf of the plaintiff. Then counsel submits that what is the amount that is paid is not the consideration, and that there is an agreement between the parties that the amount there was an agreement to sell the property is not in dispute. It is submitted that he has relied on the judgment of the apex court in case of Bala Saheb Tayan Dio Naik versus Appa Saheb Tataria Pawar, 2008 for SCC 464, and also another judgment the apex court in Gomati Nagam Pillai and others versus Palani Swami Nadar, reported in 1967, 1 SCR 227. Basing on these judgments, when counsel submits that in respect of immovable properties, the time is not the essence of the contract, and still the plaintiff can, even after the time mentioned in the said agreement, the plaintiff can maintain a suit for, can maintain a suit for specific performance and is entitled for the specific performance. We had also relied on the section 2E of the Contract Act, where 2E and H of the Contract Act, and relying on the same, he submits that every promise and every set of promises forming the consideration for each other is an agreement, and an agreement enforceable by law is a contract. Relying on this, he submits that it is already agreed by the defendant by filing the written statement that there was an agreement between the parties to purchase the property at 90 lakhs, and an amount of rupees 10,000 is already paid. He submits that unless and until an injunction is granted, even if the suit for the specific performance is decreed, still he will not be in a position to enjoy the fruits of the decree. If multiplicity of if third party rights are approved, it will give rise to multiplicity of proceedings. Further, when it comes to I number 4 filed by the defendants are concerned, he submits that that when he being an agreement of holder, he has every right to bring to the notice of the general public that in respect of the said property, no further agreement should be entered, as no further transaction should be made in respect of the said property, and the court had restrained the plaintiff from doing so, which is also contrary to law, and the court ought not to have given such an order restraining the plaintiff from doing any of the acts as sought for by the defendants. He submits that unless and until if the status quo, even if this court has already granted an order of status quo pending disposal of the suit, if the status quo order is enforced, it would serve the purpose, and it would be in the interest of both the parties. Next. Then counsel appearing for the defendant 1 and defendants 2 to 6 have submitted their arguments. Then counsel appearing for the defendant submits that the plaintiff is in the habit of entering into these kind of transactions, and even as on the date of the filing of the suit, there is no material before the court to show that he is ready and willing to perform his part of the contract. And when he failed to demonstrate before the court that he is ready to pay the sale transaction, he cannot maintain the suit. Further, the agreement of sale is an unstamped document, and basing on that, he cannot maintain the suit. The trial court had rightly considered all these aspects as he has failed to make out a prima facie case, had dismissed the IAS filed by him, and no grounds are made out seeking interference with the said order passed by the trial court. Next paragraph. Then counsel appearing for defendant number 2 to 6 submits that they have purchased the property and they have been in possession of the property. He submits that contrary to the agreement of sale, when survey number 66 and 328 are the survey numbers as per the agreement of sale. He has also included survey number 67 and has
Alleged agreement.
The alleged agreement, and survey number 67 is also included. The manner in which the said suit is filed, the manner in which the relief that is sought, on that ground itself, the suit has to be dismissed. He submits that they are the bona fide purchasers. If any order is passed, any interim order as sought for by the plaintiff is passed, it would cause a lot of injustice to them. And in fact, the balance of convenience is in favor of the defendants rather on the part of the plaintiff. He submits that the trial court had rightly passed an order. Next, having heard the learned counsel.
Defendant number one, my lord. I'm for a defendant number one,
Yes, defendant number one, and he is for 2 to 6.
2 to 6.
That's what I, having heard the counsels on either side. There is the material on record. The suit is filed for specific performance of an agreement of sale dated 8/7/2021. According to the plaintiff, as per the said agreement of sale, the defendant has agreed to sell the property, and he has paid an amount or sell the property at 90 lakhs, and he has paid 10,000 towards the earnest money, and remaining amount has to be paid within 6 months. And after paying the said amount, the defendant would execute the sale deed. According to the defendant, he has paid, he has applied for the bank loan. And even before he could obtain the bank loan, the defendant started, when he came to know that the defendant is going to sell the properties and create third-party rights, he issued a legal notice on
13/8/20.
The plaintiff, according to him, it was returned by the defendant. According to the defendants, that said notice is not received by the defendants. Thereafter, the defendant has executed a sale deed in respect of defendant number one, executed the sale deed in respect of defendant number 2 to
6.
2 to 6. The trial court has observed that the 6 months' time, even if it is taken the 6 months' time, he has issued the notice after 1 year, not as per the agreement within 6 months. The plaintiff had not taken any steps, but also, and on that, the submission of the learned counsel for the appellant is time is not essence of the contract, particularly in respect of the immovable properties, and they had relied on some judgments which are referred in the above paragraphs. The trial court has also given a specific finding with regard to the loan amount, and the loan that is applied is by the father of the plaintiff, but not by the plaintiff. The court also felt that prima facie, there is no ready and willingness on the part of the plaintiff, and had refused to grant the relief. The legal proposition as far as whether the agreement, whether the time is the essence of the contract, and whether a suit is maintainable or not, whether there is an agreement of sale or whether it is a receipt, whether such a receipt can be taken into consideration, whether it is a stamped one or not. All these aspects have to be decided by the court during the course of the trial. When it comes to the prima facie case, for a property which is supposed to be purchased at 90 lakh rupees, the plaintiff had paid an amount of rupees 10,000. Now the learned counsel for the defendant submits that for such an amount, how can for an amount of rupees 90 lakh, he has paid only 10,000. When it comes to a contract or an agreement between the parties, it is for the parties to decide what would be the terms and conditions of any agreement between them. Whether as far as agreeing upon selling the property at 90 lakhs, there is no dispute, as the defendant himself has agreed. According to the defendant, the plaintiff has not come forward after 6 months, which made him to sell the property. It is also not in dispute that the defendant has not issued any legal notice to the plaintiff to pay the remaining sale consideration. Now, all these issues have to be decided by the court during the course of the trial. This court, as far as the readiness and willingness on the part of the plaintiff is concerned, the learned counsel submits that he has obtained the loan. this court has, the trial court has also observed about the loan that is in the name of the plaintiff. Obtained, the legal opinion that is in respect of the application made by the father of the plaintiff. And no other document is filed before the court to show that the plaintiff is ready and willing to perform as part of the contract, which is the sine qua non for filing a suit for specific performance of an agreement of sale. That would be the case, that would be the prima facie case in facts and circumstances of this case. Whether basing on a legal opinion, whether the bank would grant a loan to the plaintiff or not. And what has happened subsequent to the agreement of sale till filing of the filing of the suit, which is almost after more than a year. All these aspects were not stated by the plaintiff were not stated by the plaintiff. Now, basing on that, basing on such facts of the case, the court cannot pass any injunction directing the defendants from interfering any injunction in favor of the plaintiff. This court has also perused the plaint, wherein the plaintiff had added one more survey number, which is not even part of the agreement of sale. No doubt there is no finding on that by the trial court. While looking at the plaint, this court could see that the survey number 67 is added, which is not part of the agreement. And even what is the boundaries and what is the smooth schedule property is not properly mentioned in the plaint. The defendants 2 to 6 or the bona fide purchasers of the property has the case of the defendant that no notice is served about the filing of the suit. So they have two transactions have already taken place even before the suit is filed, and the other two properties are after filing of the suit, and according to the defendants 1 to 8, which is not in their knowledge at this point. And in these facts where a 90 lakhs property is an agreement, the money that is paid is 10,000, and nothing on record to show that there is willingness on the part of the ready and willingness on the part of the plaintiff to pay plaintiff to perform his part of the contract, and already by the time the suit is filed, the third party rights have accrued. And further, considering the manner in which the property is described in the plaint, this court is of the considered opinion that the plaintiff is not entitled for any injunction as sought by him by way of IA number 2 and IA number 6. Coming to IA number 4, as the matter is seized off by the court, now at this point of time, the plaintiff cannot give you any kind of the paper publications or the WhatsApp messages, and further, there is no dispute about the fact that the defendants are in possession of the property, and the trial court had rightly allowed the IA. In that view of the matter, this court finds no reasons to interfere, and accordingly, all the appeals are dismissed.
My lord, may kindly observe these observations only for the respect.
Yes,
in
sir.
respect. Otherwise, the readiness and willingness, court has said that there is no
This,
readiness and
as,
willingness.
All these observations are for the purpose of deciding this interlocutory application, and the court shall not consider this as an expression of the court and shall independently decide the case on the merits of
the
it.
case.
On the merits of it.
Merits
Yes.
of it.
week's time.
Week, post next week on Thursday. Next Thursday. Yes, next.
For the respondent, your lordship, filing the objections today, a date will be fixed for arguments. Senior is unwell and she has.
Earlier also you sought time.
For filing the objection, we are filing today. Your lordship. Date
What objections you are filing?
objection along with two documents which the trial court relied on for passing of the impugned order. That may be taken, but the objections are there.
When do you want?
We can eat it.
Lord, my copy is not given. Morning, they gave me the copy,
No,
but
he denied to take.
no, the reason, the annexures are unreadable. You can't read it, you need a micrographic,
If you have you filed it in the registry?
He denied to sign, so we couldn't file it without serving. He's refusing to take it. If
I
you
did not
peruse the-
refuse, my lord. I said, please give me along with a proper readable copy. That's all I
It's
said.
an email thread printout, your lordship. The same thread is also
My lord,
filed with
please
the
see
lower
the
court.
document, my lord. Anybody can read. And he comes with a logic.
Oh, now if
Same
it is
thing.
placed, if he takes it to the registry, they will not, they'll not pass this.
That's
what
what
we
we
are-
It is not legible.
Milad, he would have anyway come to me for my signature in advance. I would have said the same. I am ready to take it. Please give me a one which I can read because I have to get prepared. I have to counter.
Then it will go on.
No, Milad, logically, what
No,
is,
let him come up with it. Now it will go on. Now what you have to understand is now if you take that, any of the registry will refuse to number it, then he has to do.
Objections and all. will
objection,
not
they
be
won't
checked.
do all that.
Why?
Only scrutiny of writ appeal and writ petitions will be checked.
Why
by the-
anything that is fine, they'll take.
Yes, yes, objections, they will not do it. ma'am.
Huh? They have to, it's filed by a waiver in IA.
No, in that case, I will put a comment subject to the
Yes,
providing
yes,
this,
yes.
I'll put it, Milad.
Yes.
Milad, I
Was
have.
this matter on 28th of August? Yes, please.
Pacho.
It may pass over. And it may pass over. Pass over, there is some difficulty. Can it be taken up tomorrow? Please?
Tomorrow. At the request of counsel for the respondent. Pose this matter tomorrow. Yes.
I'm sorry, my lord, we are not able to hear the bench clerk. We don't know which serial number is going on, sorry.
Serial number 14, Jaiprakash Reddy M.
Mike is far away or somewhere for you?
Audible, my lord, now.
Yes.
Serial number 14, Jaiprakash Reddy M. For petitioner.
Your petition is fine.
Sana Kumar.
That's for respondents, Millards. May I seek for a short accommodation, Millards? My objections are ready. The Millards,
Why objection? What are this RP? What objections? Court has already before this RP comes, there are so many objections for at every state, writ petition and all. More again
now
RP
they have
again.
filed some documents, Millards,
For what?
seeking that on medical expenses, they have filed certain documents, Millards.
Along with the memo they have filed, but for that, what objection?
When will you file?
Let's, 3 days accommodation may be given, I'll be.
Post on Tuesday. At the
Next
request of
Tuesday, no?
calls for the respondent.
7-8.
Yes.
Serial number 15, Abubakar.
Serial number 15, I
For
appear for the petitioner, my lord.
I appear for the respondent.
In this case, I filed the translated copy of the judgment of the trial court, my lord, separately. And also compilation of judgments, which clearly shows even the wife is fairly employed also. She is entitled for the
Who appears
maintenance.
for the respondent?
My lord, I appear for the respondent, my lord.
You received all those documents?
I have received only the translated copy, but not the citations, judgments copy.
Serve on her. Poses on 4th of September.
Lord,
Calls for the respondent.
which date, my lord?
3rd,
Fourth, it may be on 4th, my lord.
4th.
4-9.
4th, oblige.
Oblige me.
Serial number 16, Prasanna VR. For petitioner, Pratima SK.
What is this?
This is regarding the maintenance, they have not paid as your lordship had ordered 2,15,000 within 4 weeks. Another sum of 2,50,000.
No representation on behalf of the petitioner post this matter for dismissal tomorrow.
Plus,
Yes.
can I, may I request for day after me?
Yeah.
Great.
Till number 17.
Plus, I'll also produce, sorry, he has not produced the affidavit of assets and liabilities that was filed. I think that will be important for your lordships to decide. May a week's time be granted. I have applied for certified copies.
Then we'll have, if you have no urgency, we'll have it next week on 4th of September. Post this matter on 4th of September.
4.
Yes.
Till number 17. Naveen TK, 14%.
Give that. Where is the docket proceeding? On 19/8/2024, as there is no representation, this matter is posted for dismissal today. Today also there is no representation. This is a writ petition of 2013, wherein even till now, the office objections are not rectified accordingly. It appears that the party in person is not interested to pursue the matter, dismissed as for non-prosecution. Yes, next.
Till number 18.
Here for defense counsel.
Narendra Gowda.
Yes.
But the appeal was dismissed for the non-compliance of the office objection. Office objection meant for the payment of the court fee. Now the court fee has been paid, my lord. Therefore, there is a delay in making the application for recalling the
When is the
order.
order?
2018, my lord.
When was it filed?
Appeal was filed in 2016. Well, regarding, my lord, enhancement of the compensation, this
No,
appeal.
when the appeal is dismissed in the year 2018,
Yes,
till
my lord.
2024, what was the appellant doing? Recalling application is filed in the year 2024.
Yes, my lord.
What is he doing? What are the reasons that are stated?
The reason, my lord, that he could not mobilize the court fee regarding the enhancement of the court fee, compensation. And also, my lord, there is a marriage of the daughter and also he met with some health problem, paralytic stroke.
So where is that IL? Let's read.
Rashmi, kindly see paragraph 4 of page 3 of my application. The above matter was posted before this, got it, my lord? Paragraph 4.
Yes. How many, para 3, how many times the matter is listed?
True, my lord, it is true. I am not, an agriculturist, my lord, as a matter of fact, in some of the connected matters, my lord, the court has granted 37,000 rupees per kunta. Here, my 9,000 has been granted. And it is very near to the Valainarsipur town, my lord, the land in question, and it was fit for.
No copy is given, my lord. I have no file.
For the delayed period, my lord, I don't claim any interest or. For
The
agriculturist.
I number 1 of 2024 is filed to recall the order dated 11/10/2018. As the order was, the appeal was dismissed as he has failed to comply with the office objection. Now the present IA is filed with a delay of 2084 days. In recalling the application, it is submitted that the petitioner is the appellant is an agriculturist, and as he couldn't, as the court fee has to be paid is 2,50,000. I was not able to get the said amount, procure the said amount. He could not comply with the office objection. And also it is stated that his health condition is also not good. Further, it is also stated that in respect of the very same acquisition, the amount is enhanced from 9,000 and odd to 30,000 and odd.
37,000 per gunta. 37,000 per gunta.
37,000 per gunta. Unless and until the delay is condoned and the appeal is restored to file, it would cause a lot of hardship to the plaintiff, to the appellant. The appellant. Next para. Considering the fact that this is an appeal arising out of the land acquisition case, wherein the land of the appellant is acquired. And further considering the fact that in the other appeal, with respect to the same acquisition, there is a substantial enhancement of the amount. And as already the court fees is paid by the appellant. Considering all these aspects, this court deems it appropriate to condone the delay of 2,084 days in filing the appeal, and the order dated 11/10/2018 is set aside and the appeal is restored to file. However, on the condition that the appellant will not be entitled from 11/8/2018 till today, that is till today. Post this matter. So the papers on him.
After complying the office objection.
The remaining office objections shall be complied within a week. And within a week, or else the appeal shall stand dismissed without further reference to the court. Yes.
Number 19 at 19. Mahendra Ji.
Appellant in this case, ma'am.
Yes.
The respondent number 5 has filed an application for impleading. Morning, they have filed a memo for withdrawal. Now,
That's the only thing coming up for consideration now.
please, Manoj.
IA number 1/23 is filed to implead themselves as respondent number 5 in this appeal. Now, again, they've come up with a memo. Where is he? He has taken back. Let him come, take the order. A memo is filed stating that they want to withdraw IA number 1/23. Accordingly, the IA is dismissed as withdrawn. 1/23 is dismissed as withdrawn. Is 20?
Till number 20.
Manoj, that's an interim order that may be extended.
Granted, is extended till the next date of hearing. Post this matter on October 15th. Yes, next. 20th.
20. Rajshekar S.
He is Passover.
Cell number 21. Tumbigi Prabhugaud.
Yesterday he moved a slip.
Yes, your lord.
Passover. Yes, 22.
Cell number 22. Gohar Unisa.
My lord, I have filed application for recalling the order dated 12/6/2024, my lord. Dismissed for non-prosecution, my lord.
When was it
Non-compliance of office objections, 12/6/2024, my lord.
12/6?
24.
Have you complied with the office objection?
Please, my lord, I have complied all
All
the office
office
objections.
objections.
Please, my lords.
IA number 1/24 is filed. How much is the delay? When is the order?
Delay, order was on 12/6/2024.
On 12th June 2024.
And there is a delay of
The
filing.
order is passed, granting a week's time for compliance of office objections. If the office objections are not complied with, the appeal shall stand dismissed without further reference to the court. This order is passed on 12th June 2024. Land counsel appearing for the petitioner submits that they've complied with the office objections. As such, the delay of how many days?
26 days.
26 days may be condoned and the appeal may be restored to file considering the submissions. The IA number 2/24 is allowed and the order dated 12th June 2024. First IA number 1/24 is allowed by condoning the delay in filing IA number 2/24 to recall the order, and IA number 2/24 is allowed by recalling the order dated 12th June 2024, and the appeal is restored to file. Post this matter for preliminary hearing next week.
Cell number 23.
Lord, it may be taken up day after, my lord.
Day after.
Obligation.
Yeah.
Yes, we'll call after.
I wanted to mention serial number 17.
You can't mention, your advocate should be there. This is not a lower court.
8 ನಡೀತಾ ಇತ್ತಲ್ಲ ಅಂತ ನಾವು ಹೊರಗಡೆ ಇದ್ವಿ ಅಲ್ಲಿಂದ ಬರೋಷ್ಟೊತ್ತಿಗೆ 17 ಆಗೋಗ್ಬಿಡ್ತು. Actually, it was.
Was it written on the cause list that it's only advocates who are supposed to mention before the court?
So can I mention that at least in the afternoon, madam? 17.
Advocate shall only do it.
DMP party. ನವೀನ್ ಟೀಕೆ 17 DNP ಆಯ್ತಲ್ಲ ನೀವ ಸರ್ ನವೀನ್ ಟೀಕೆ
ನೀವು ಹೇಳ್ಬೇಕು ಐ ಆಮ್ ಎ ಪಾರ್ಟಿ ಪರ್ಸನ್
ಅಂತ ಹೇಳ್ಬೇಕು
ಆಸ್ ಇಫ್ ಯು ಆರ್ ಎ ಪಾರ್ಟಿ ಮೇಡಮ್ ದೇರ್ ಇಸ್ ಎ ನೋಟ್ ಬಟ್ you have to submit specific Yeah, the dictation is very, dictating orders to them. ನೋಡಿ ಹಿಂಗ್ ಆಗ್ದಾಗ ಈ ತರ ಆಗುತ್ತೆ ನಾ
ಯಾವುದು ಯಾವ್ದಾದ್ರು went on and when she said, it's not possible, we didn't consider it, if you remember.
I did not mention the Ugadi festival.
No, that meant it was mentioned, but she said I cannot come. We'll see. Yes, next.
Very
much obliged.
Till number 20. Till number 20, Rajshekar S.
For the appellant.
For appellant.
So there is a delay of 7 days
Hmm.
filing the present appeal, which may be kindly condoned.
20?
7 days.
What is her number?
Serial number 20.
Till number
20.
20.
No, the council is appearing for this one. Where is he?
Notice is not yet ordered now.
No, it is there. Roshan MC. 20.
They are on caveat, I guess.
Have you served papers on them?
Please. We got to know about this only now. We're not.
Serve the papers on them.
I'll do that.
Petition shall serve the paper. Appellants, counsel for the appellant shall serve the papers on the counsel for the respondent. Pose this matter day after.
Grateful.
Yes.
For 21. Prabhu Tumbige.
Lordship, kindly pass over.
Yes.
DD is ready, Lordship. Lordship, kindly pass over. Senior is ended another court.
How many times? Morning, no representation. Yes, next.
It is
Pass
ready.
over. Yes. Short pass over. Ask him to come in 5 minutes. Yes.
Till number 23.
Yes.
So that for the respondent, I will request a short pass. Period is
For dictating orders.
Yes. Short pass over. You should have at least removed that caption, orders at 4:15. Orders at 4:15, now what to do?
Present, madam. Serial number 24.
Huh?
Serial number 24, where for the appellants.
No, whatever are the matters, next posted, don't post under this cap. Let it be posted, not at 4:15 PM. Yes. Let there be an order, but post it like that.
We have amended the cost title.
Hmm?
Office objections are complied. We have amended the cost title. Also, we have filed amended cost appeal. Title appeal.
24.
You have completed?
Yes, ma'am.
It is submitted to the office, objections are complied with. It's a MFA of
2013.
matter for admission
Complaint.
on Tuesday. Yes, if all the objections are complied with, post this matter for admission. Yes.
So next to file and like.
If anybody is there, they'll attend all the 26.
If anybody is there from serial number 24 to 25. 25 to
What is 26? Letter of extension of for further 19 days. Do that.
25, till number 25, 26.
25. And again, call it not
26.
taking steps for bringing the laws. Suppose this a week's time is granted for taking steps. Till default order. Yes. Give that. Letter. This court, by order dated 10/7/2023, had directed the trial court to dispose of the appeal, to dispose of the suit within 1 year from 10/7/2023. Now, a letter is addressed by the first additional city civil and session judge. Sought for 90 days time, and there are several matters pending before the said court. And in spite of the best effort, she couldn't, the learned judge couldn't dispose of the matter. In the said request, another 90 days time is granted, disposing of the suit. Yes, next.
Till number 27, A. Murugan. Ravindra.
Give the
20.
file. File. Finally, a week's time is granted for complaints or same default. Next, 28.
Till number 28. Ravindra Prasad B regarding maintenance.
Keep this matter aside. Consulate will call it at 4:50.
29.
Yes, 29.
Prashant BR.
Give that. Same a week's time. Default order.
Till number 30. Till number 30. Anand HC.
Same order.
1 week. Till number 31.
Same. All default next week, a week's time on today is Monday. Let all these matters come up on Wednesday and our 4:30. All these matters or 4:15 you see at 4:30 on that day. Yes. Yes.
Number 31, 30, 32 disposed, 33.
Serial number 33 for the appellants. It has become infructuous, my lord. Appeal, the OS is already disposed of.
Submitted that the main suit itself is disposed of. This is MFA has become infructuous, dismissed as infructuous. Yes.
Till number 34.
34 same.
For kindly grant.
Week's time. Default order. Yes, 35.
Till number 35.
Same order.
Till number 36.
My lords, 36 and 37 I pay for the appellant. My lords, there are 5 in fact connected appeals in this. 2 of these, the office is posted before this bench because of an undervaluation. However, 3 other appeals are there which are lying before the division bench. In fact, in MFA 8220, I'll give all 5 of those appeal numbers, my lords. But in 8820 before the division bench, order has been passed tagging all 5 matters to be placed before that bench. We paid the court fee as well in one of the appeals.
It has to go before
It
the
has to
division
go
bench.
before the division bench.
Then comes for the appellant submits that.
36 and insofar as the office objection.
It is submitted that the connected matters as per the valuation are listed before the division bench. And there is an order directing these matters also to be tagged on to those matters.
Please, ma'am.
Hence post along with,
MFA 8820
Write it,
and connect.
write
I'll
it.
give that, ma'am.
post along with so and so. Next 38.
Serial number 38 urgent. 39. Serial number 39 Nagarajulu Naidu.
Or board,
Appear for the respondent.
yes, and the contesting respondent.
So only sole respondent is there?
No, other respondents there,
Are there.
because from the purchaser, I am in possession of the property,
A week's time is granted finally for taking.
Monday at least. Monday next.
Week. For taking steps, it is coming. For steps, it is
For
coming
other respondents.
for other respondents.
Naturally, other respondent is not appeared because of the trial court, they are not appeared. They are only contesting. In the trial court, they will not lead the evidence.
Then
for-
let them come, but we'll see at 4:15.
Yes, I wait.
Yes.
Also.
Yes.
Serial number 40. Manjunath BR.
Why is it listed? Give that at 4:15. This is not for non-complaint. Order, why it is listed in this? Read this. Call this matter again at 4:15. Because it is mentioned in the list. That's a whole different thing. Yes.
Serial number 41. Serial number 41.
Yes. 4:15. 42.
42. 42. Yeah, Ganesh.
PF But the respondent number,
Second time.
My lord, in this case, respondent is intentionally not appearing before this honorable because she has procured an order by suppressing material facts. She was a working woman. Thereafter, my lord, I submitted the same.
what about the notice? It says that to the respondent for the second time, furnishing of PF.
True, my lord. But on the previous occasion, my lord, I mentioned this to the same honorable court, the previous bench, stating that she is intentionally avoiding the notice because the same address, whatever she has been provided in the
What
first statement.
happened to that? What happened to that notice earlier sent? Received. So then,
It has been-
when was it sent?
It is of 2009.
Pay the process.
It is of 2019 case.
Pay the
The
process.
trial. My lord, other submission is that we were directed to issue notice upon the respondent counsel to serve it
Do
up.
that one.
I have already done that, my lord. I have already completed that. I have also placed an acknowledgement with respect to that.
Get it. What is the name of the advocate? Is it in Bangalore?
Yes, my lord.
Look at it. What is the name of the advocate? It is submitted that as per the orders passed to this court, he has served the notice and the counsel appearing before the trial court and file a memo to that effect. Bring the name of Ramappa P.
Ramappa P. Ramappa P.
He has posed this matter on Thursday, next Thursday.
My lord, Friday at least, not this Friday.
It's a 2023 one. We'll see next Thursday. Yes.
Acha. Date maybe. My lord, one thing my request is this. Till date, there is no stay on the case. My lord. Till now, till date, she has suppressed the files and she has procured the order. Even after that, she is pressing the court on the said orders. Until then, the further proceedings may be stayed, please. My lord.
Not hearing it, how can the court do it? Yes.
I'm ready to hear interim application at least.
Look at the advocate's name be printed for till 20, from 2023 till now, you were not pressing it.
My lord, we have been frequently making all the memos to before.
Yes, we will see. We'll see on next Thursday.
Date
It's
may be
43.
fixed. My lord.
Next
Please.
Thursday,
Much.
yes, 43.
Hearing cell number 43, Hari Prasad MP
Hearing for the appellant,
for appellant.
seeking for adjournment. Kindly have this matter on tomorrow.
Pose this matter on September 23rd. Request of learned counsel for the appellant.
Cell number 44. Shivraj Patil, corporate appellant. Ajay Prabhu M.
Same.
23rd. Cell
Yes.
number 45. NB Nijalingappa.
This
45.
also no representation on behalf of both the parties earlier and this on the September 23rd or 24th.
That pass over.
Yes.
Pass over cell number 21.
Lordship, a DD of 3,80,000 is ready, Lordship.
Hmm.
The
Your Lordship.
Stay is already
order
with-
passed On 17/2/23 in the family court. They filed an appeal and the 62.
What is this slip moved yesterday saying that something is happening?
Lordship, we have actually interim order is already vacated, Lordship, but the amount is ready, Lordship. 3,80,000 amount as per the interim order, we have kept the amount ready, Lordship.
The amount is 10 lakh, 30,000, your Lordship.
Huh?
As per the interim order, it was 2 lakhs.
Come to this order dated 5/3/2024. An amount of rupees 2 lakhs before this court in the next 4 weeks and should continue to pay an amount of rupees 30,000 during the pendency of the
Yes, sir.
proceedings. The respondents of the petitions are compared to the interim order passed this one, he has not even paid him. For possible coming.
Your Lordship, there was a 60,000 rupees maintenance order passed.
No. Even if we calculate from 5/3/2024, as on the day 2 lakhs.
Your Lordship.
1 minute,
Yes.
as per the interim order, it is 2 lakhs. Then from that is it's order dated 5/3. So from 4th month. 5 months. 5 into 3. 15. 1,50,000. Plus 2 lakhs. 3,50,000 is
3,80,000 is ready, Lordship.
Give it
Lordship,
to.
a permit. Please.
Your Lordship, on 17 February 2023, the order by the family court was passed for 60,000 per.
Oh, this court has vacated the order, as yes, court has already granted him an interim order. As he has failed to pay the amounts, it is vacated. Oh, he's ready, you will get some money. Why do you, we'll hear it on the merits of it. Yes, this court on 5/3/2024. This court on 5/3/2024 had vacated the interim order. As the petitioner had failed to pay the maintenance. Today, for an amount of rupees 3,80,000, the petitioner has placed before the court stating that he is ready to pay. And now the respondents are pressing for the execution. Learned counsel, the respondent submits that as the petitioner has failed to comply with the orders passed by the court, and the stay is vacated, now they cannot seek for the stay. They cannot again seek for the stay. It is a case of the fact that the husband is not paying any amount towards maintenance. An interim order is passed. From the date of interim order till now, the petition had to pay an amount of rupees 3,80,000. And he has come up with a DD. And now, if the amount, as he is not paying the amount, if she receives the amount, and now if an opportunity is given to the petitioner to put forth his case, it would be in the interest of both the parties. In that view of the matter, the petitioner shall hand over the DD of 3,80,000 to the respondent advocate. The party is also present before the court. And as such, in view of the same, the order dated 3/1/2024 is revived, and there shall be stay of all further proceedings till the next date of hearing.
FLW may be recalled, Lordship. FLW is issued, Lordship, in the lower court.
That's why
FLW.
now the statement, it is submitted that the warrants were issued in the submission, sir. When we'll post this matter on September 18th, post this matter on September 18th.
18th.
Yes.
47.
Yes.
Chair number 23 for dictating orders.
As directed, Mr. Honorable Lord, I filed in calculation chart regarding the expenditure, but.
Now,
the
what I
office-
request both of you is, once one of you complete your argument, then I request the other advocate to advance the argument. You
Hello,
understand?
As
I said first you come, once when she is arguing,
Yes, ma'am.
you don't submit, and when you are arguing, let her not submit.
Yes, ma'am.
What is that you have filed?
I have filed a detailed expenditure which is expecting. the
May I
petition-
start, my lord, because my writ petition is first, and I have got an interim order here by your lordship.
No,
So if
limited, there are no arguments.
the
now.
argument is over, only
Only
facts.
on that, let him say, you can submit.
Very good.
Yes. Very good.
My lord, here in where the lower court has completely never looked the income of the husband, wherein even the court has preserved, my lord, before that,
Please,
before. No,
we are
no,
not going into all
Ma'am.
that arguments.
Yes,
What I wanted to know is what are your expenditure?
Yes, ma'am.
That you tell the court. I already heard all of you here,
Yes,
both of you enough.
For the
Yes.
petitioner food expenses at a residence to meet the same standard of nutritious food which the respondent is having at home. She has not been provided with any food there. She has to manage.
40,000 next.
Yes, madam. For the purpose of food, when the respondent compelled to have food outside in few circumstances.
Yes, next.
My lord, for that. And towards the clothes and dress, the respondent is using all the branded clothes wherein one Calvin Klein t-shirt costs around 10,000 per shirt. And per trousers of the petitioner is also entitled for the same, wherein the present petitioner is using all the old dresses itself.
Yes.
My lord, towards the accessories like bangles, sticker, chain, earnings, watches, sandals, slipper, etc., my lord, which is the basic need, my lord, towards it 15,000 per month, my lord. Towards the medical expenses, cosmetics and other expenses, my lord, wherein the petitioner is suffering with the knee joint pain and for which she needs to take the regular medication and physiotherapy treatment. Even she is suffering from high fever, tension, panic attack, for which she need to take regular treatment and medication. Due to the negligent act of the husband, she is not in a position to show it to a good doctor and good hospital, for which, as per the at least 4 to 5 lakhs is needed. And my lord, though the respondent is being, my lord, that is, I have, it's a overall cost, my lord, I have bifurcated to a monthly wise also, my lord, in the second column. Though the respondent is being the school fee, paying the school fee and tuition fee to the children, he has completely neglected to look after the children, always being with him, with them as like a mother, and due to which the petitioner is supposed to.
If at least your client is not understanding it, you should understand and you should advise her unnecessarily that these kind of expenditures that they give, the court gets the impression of the court would be something. What is this? 8, please tell the court. Every month, 60,000, what she will do?
My lord, wherein, my lord, this is the humble request before the court. Will leave to lordship to decide on this.
Reasonably, you should tell.
Allah.
Not about I will, it is like a bargaining, like you will give 5 lakhs, 6 lakhs, and the court will, okay, let me give 1 lakh to the, not the way. You should come before the court with the actual figures. What are all this?
Oh, my lord, wherein I have categorically categorized that these are the needed for the her commitment, my lord. And my lord, she is possessing with the loan also, wherein she has to repay that. At that I have produced the document also, gold loan, other loan and other hand loans which she has managed and which is deposited to her bank statement by the mother.
You want 6 lakhs, 16,300 per month. Per month as expenses.
My lord, no, my humble submission before this honorable court with regarding that, the landmark judgment wherein Supreme Court has held.
Yes, please pass on. Yes. Yes.
Well, in the first case, my lord, wherein it has clearly held that the maintenance, interim maintenance and maintenance laws
To
has.
the relevant paragraph, not the head note.
Yes,
Come to the relevant paragraph.
Yes, my lord. With regarding.
Paragraph number?
My lord, in the paragraph number A, my lord. My lord, which in the first page, my lord.
Head note, let us not read. Let's go to the order.
No, it has been elaborately given and it has been.
The order. That is somebody editor's head note will not read.
This has been elaborately explained, wherein, my lord, in the landmark judgment, where it has held, but because of this judgment, the assets and liability has begun in India, that is compulsory, made compulsory. The purpose of making each party to file an assets and liability, because the maintenance amount will be awarded on the basis of the source of income.
Now again, this court will hear another 1 hour, both of you.
You
have already argued that some account he has not given, that all that you argued.
No, I'm not that. Why, my lord, why trial court has erred in considering all those aspects. The maintenance amount which she was needed, which has not been ordered.
You're relying on Rajneesh versus Neha,
yes,
which speaks about filing your assets and liabilities. And where did you comply? Where did you file before the trial court your expenses?
No, I filed assets and liability.
But what are your expenses?
My lord, wherein I have
assets and liabilities also includes your expenses.
Yes, my lord, that I have stated.
Where did you say?
For which, my lord, I have stated in general, my lord.
No.
Wherein assets and liability, no, my lord, in assets and liability.
When you rely specifically on a judgment, please understand. When you rely specifically on a judgment, you should specifically follow that, not generally.
In assets and liability, my lord, I have stated whatever information it is sought in the assets and liability, which has been directed by the Supreme Court.
Let us see the judgment. Let us see the judgment. Not, where is that judgment? Rajneesh versus Neha, not this.
My lord, in the clause C, my lord.
Not clause C, come to paragraph.
In the first page, it's. Oh.
Read para number 63. Payment of interim maintenance. This is which journal? SCC.
My lord, it's reported in the AAR, SEC everywhere, the above it is shown.
What you are relying
The
on?
Supreme today. I
Payment
downloaded.
of interim maintenance is there, that you read. There is another copy. Another copy of Rajnish versus Neha.
The quantum of the
Payment of
criteria for
interim-
determining the
Payment of interim maintenance. The issue of interim maintenance is decided on the basis of pleadings, where some amount of guesswork or rough estimate takes place, so as to make a prima facie assessment of the amount to be awarded. It is often seen both parties submit scanty material, do not disclose the correct details, and suppress vital information, which makes it difficult for the family courts to make an objective assessment for grant of interim maintenance. While there is a tendency on the part of the wife to exaggerate her needs, there is a corresponding tendency by the husband to conceal his actual income. It has therefore become necessary to lay down a procedure to streamline the proceedings, since a dependent wife who has no other source of income has to take recourse to borrowing from her parents, relatives during the interregnum to sustain herself and the minor children till she begins receiving interim maintenance.
Lord, the criteria for determining quantum of maintenance, if your lordship read that, in that it covers.
Where is that?
The next page, my lord. Subclause 3, that is Roman 3, my lord. Permanent alimony, next is criteria for determining quantum of maintenance. The two paragraphs, if your lordship read, it conveys the meaning, man.
Quantum of maintenance. The objective of granting interim permanent alimony is ensure that the dependent spouse is not reduced to destitution or vagrants on account of the failure of the marriage and not as a punishment to the other spouse. There is no straitjacket formula for fixing the quantum of maintenance to be awarded. The factors which would weigh with the court inter alia are the status of the parties, reasonable needs of the wife and dependent children, whether the applicant is educated and professionally qualified, whether the applicant has any independent source of income, whether the income is sufficient to enable her to maintain the same standard of living as she was accustomed to in a matrimonial home, whether the applicant was employed prior to her marriage, whether she was working during the subsistence of the marriage, whether the wife was required to sacrifice her employment opportunity for nurturing the family, child rearing, and looking after adult members of the family, reasonable cost of litigation for a non-working woman.
So in this, my lord, the criteria is also important if she's qualified. I have one more judgment which I will rely later.
My
That
lord,
qualification
very-
when you have,
No, very-
don't go for work.
Position of the parents of the applicant family would not be material but determined. So maintain depend upon factual situations. All the claims maintenance based on various factors before it. So, at para 84, the Apex Court has referred to the Delhi High Court judgment. It says status of the parties, reasonable wants of the claimant, reasonable wants of the claimant, the independent income and property of the claimant, the number of persons the non-applicants has to maintain, the amount should and aid the applicant to live in a similar lifestyle as she enjoyed in the matrimonial home. These are all the things which you have to state. That is what at page number 84.
No, that and all, my lord, we have categorically stated that what is the amount debt and what is the expenditure at present she is incurring and what is the amount she is expecting from the court with regarding to maintain her life in the same standard of life that her husband. That and all we have stated in the assets and liability. In a detail, it has been categorically.
Just she will not be given maintenance, basing on what the husband is getting. And also other factor
No,
is,
my lord,
what is her requirement? Husband must be having 10 crores of income because he's getting, court will grant 5 crores to her. No, it's about, she has to tell what is her expenditure, what is her requirement that you didn't even tell before the court, except giving a big figure of so and so. There was no break. What was the breakup? Why? What is that she wants? Never. No, when I asked you to give before this court, if this expenditure that she gave before the court is simple reason and simple ground for this court to dismiss your application.
My lord, my humble submission before this honorable court. Kindly look the operative portion, my lord, wherein prior to it, the court has held. He has never stated affairs certain liability, but he's made a submission that he keeps a cash box at house, wherein she makes use of that fund, wherein hence the court held that she is not supposed to be provided with any expenditure with regarding because she is already taking from the cash box. And for her personal income.
You understood when the court asked you,
Yes.
though it was not given before the trial court, the court asked you for this to consider to grant some amount to her. After looking at all the expenditure what she has placed before the court feels that nothing to be
My
granted.
humble submission, my lord, this court may not order this much, my lord, to a reasonable amount, my lord.
Why should I do that exercise? Why should you tell all this? And why should I grant, why should the court grant reasonable amount?
No, my lord, in order to
There's a
show the
duty-
actual picture,
there's
my
a
lord.
duty also, no, please don't tell the court that this is all a person requires. 6,16,300 per month. Does anybody spend this much? A single lady for herself? Oh, if she wants to spend, let her earn. Not on the husband.
My lord, any nominal amount.
But I'm telling you, if this is, if you want an order from the court, I want the actual figures, not this lakhs of figures. Will not grant, or else I'll dismiss your application. Please tell your client, what is this? You have no other responsibility of the family. You don't have to take care of the children. You want for yourself. You say, I want 6,16,000. That's not the purport of section 24. And it is not a punishment to the husband that if he is having a dispute with wife to grant 6,16,000. You should be reasonable in telling it. Not that I will tell some figure and the it is for the court to give some amount or the other. There was no reason for the court to even ask you to file it. I thought if you give the figure and if the court understands what's a requirement, then we'll consider it. But not 6,16,300. A single lady without the responsibility of the kids. Just to take them for a holiday, take them for a lunch, you require 6,16,000. At least how I'm really surprised how she could give all these headings. I think even in that Rajneesh versus Neha, nobody knows that these many headings will be available. Very strange. Final opportunity for you. Come up with a reasonable thing. Reasonable, I'm again telling you. If it is like this kind of a thing, straight away we'll dismiss it.
My lord, may I submit?
Yes.
If your lordship may see, even the legal expenses, 50,000 rupees per month for the lawyer. How it is even acceptable, my lord, to increase the bill, bloat a big figure so that they'll get. Now, one more thing, my lord, only one opportunity your lordship may kindly give me. I'm filing one memo where 63 lakh rupees is in circulation in shares in their own bank statements with page numbers. I'm giving it. Which bank statements? I'll give him a copy. Let him
You
also.
do one thing.
Yes,
You do one thing. Just don't give it like that.
Please.
Basing on an affidavit, you file it.
Please, my
And
lord.
let them respond.
Please,
No,
ma'am.
we will send a loud and clear message to all the litigants.
Yes, ma'am.
Who wants to exploit, the process of the court.
This is
and the
exploitation.
provisions,
This is an exploitation.
My lord, there is
Everything
no,
he's
there-
doing.
I'm ready to file one more affidavit also with regarding. There is no earning has been raised, earned out to shares. And it is the false submission they are making again and again.
No, I will file with an affidavit.
It will
now.
reflect in the bank's no, my lord. Let her show a single rupee profit I have earned.
Then you please file an affidavit.
I've disclosed it as
Not
such a
that,
liability.
now with that, she will file an affidavit.
My lord,
You file an affidavit.
file,
We
I'll
will
file.
decide it.
my lord,
We will
I have
decide.
filed the entire document, my lord. I have never suppressed, but again,
They
and again, they're
filed-
twisting
they
and
filed
making
an
the false
affidavit.
submission. My lord,
They-
they did not file the
The-
true picture, my lord.
As per the orders passed by this court, the expenditure of the wife placed before the court, where it shows that she requires 6 lakhs and odd for her monthly expenses. All the expenses on the face of it, all the amounts that are stated, this court cannot appreciate that there can be the monthly expenses of a person who do not have to take care of the children and any other expenditure except her personal expenditure. As a last and final opportunity, the petitioner wife shall file the actual required expenses. If they are the actual expenses filed, then the court will consider the same on the next date of hearing. Next para. Learned counsel appearing for the husband submits that an amount of rupees 83 lakhs.
63 lakhs.
63 lakhs is in circulation.
In the shares, ma'am.
As she is.
As per their bank statements.
As she is doing the share business. Business, which is denied by the learned counsel appearing for the wife. The husband shall file all the documents on with an affidavit and serve the same on the counsel appearing for the wife, and the wife shall file an affidavit along with, in the said affidavit, she also disclose her expenses also.
My lord,
Depending on that, orders will be passed. Yes.
my lord, that is the expenditure anticipated by this court. My lord. That is that the petitioner expecting from this court. That is not the incurred so far.
There is no anticipation. The provision is for her requirements.
Yes, my lord.
Court is
No,
not here to.
that is towards the needed amount, my lord. That
Huh?
is not the actually she has spent so far. That is the amount which she is seeking
Which
from.
law says so, that you should, in anticipation of something, you should ask for maintenance?
Allah, my lord, that much capacity she is not having at present. That is why we have filed that application. She is needed of that amount and she has been forced to.
If you want to stick to the same ground, we have to pass orders.
Allah, which she is
Please come up-
expecting from this.
Please come up with appropriate affidavit, then we will see.
Much.
Yes, post this matter on 9th of September. By the time, all affidavits shall be placed on record. Yes,
Obligement.
done. What is the past over?
The interim order may be continued in my writ petition, my lord.
Yes, in one writ petition, there's interim order. Interim order earlier granted is extended till the next date of hearing. Yes.
Obligement.
28.
Post this matter tomorrow, 28.
Cell number 20. 39. Cell number 39.
Yes.
Very for the appellate. My lordship has already heard this matter previous occasion. There are two order 39 rule 1 and 2 applications. One is filed by my lord.
Now, what about notice to the others? Not required?
That's not required because it's not required because I filed the application. R4 has filed the application, injunction application against the plaintiff.
You are the plaintiff.
Yeah,
No,
I'm
I'm
the
the
fourth
plaintiff.
defendant.
I'm the
I
plaintiff.
filed the injunction application against the plaintiff, appellant plaintiff.
That is granted.
That is granted.
So now the order is in your favor.
Yes. So they're challenging, they come.
Then what about other respondents are not necessary? to
Not
this?
necessary.
Have you filed a memo?
I'll file.
File a memo. Land counsel for the appellant submits at the as far as this application is concerned, the respondent herein, who is represented by an advocate, respondent defendant is a necessary party. And the notice to the other respondents may be dispensed with. Same, the memo is taken on file and notice to respondent number 2 to 4 is.
I am for the 4.
1 to 2.
1 to 3.
You are 3.
I am for the 4. R4.
Respondents 1 to 3 is dispensed with. Yes. What is the suit for?
This is suit for declaration, specific performance of agreement dated 20/12/1985 and for permanent injunction.
You sought for specific performance of an agreement of?
2012 to 1985.
In which year you sought this?
My lord,
In which year you filed the suit?
suit filed on, my lord, suit filed on
Already filed ಆಗಿದೆ.
10/11/2008.
10/11/2008.
2008,
How many years? 31 years.
31 years.
Too early.
My lord, there are two applications. There are two order 39 rule 1 and 2 applications. One is filed, IA number 15 is filed by defendant number 4. IA number 6, my lord,
IA number, what is filed by them?
15.
15, yes.
Plaintiff filed IA number 16
Hmm.
under order 39 rule 1 and 2 application.
Hmm.
IA number 15 was allowed.
Something is coming.
IA number 15 was allowed.
Hmm.
IA number 16 was rejected.
Hmm.
Against which, my lord, the present appeal. My lord, basically, my lord, this is suit
Your
for.
injunction is dismissed, his injunction is allowed.
Earlier, there is an interim order in favor of me. Absolute interim order is in favor of me. Lord, this is suit for declaration, specific performance of agreement dated 20/12/1985 and for permanent injunction. Very same day, my lord, entire sale consideration was received by the first defendant and possession was handed over. My lord, I filed, my lord, for additional document I filed, my lord. Kindly see, my lord, for a moment. Document number, my lord, 3. Document number 3, page number 43, my lord. Entire sale, this is site, 4060 site. Entire sale consideration was received.
For going into all this, we will see your plaint. Please come to plaint so that the court will understand what are the facts.
My lord, I'll submit. My lord.
No, that is because it's all waste of time going.
My lord,
into
this
all
is, my lord, suit for declaration and
No, we'll get
specific
to the
performance of agreement.
Plaint, come to the plaint.
Page number 67.
Yes.
Directing the defendants to pay a sum of rupees 6 lakh along with interest of 18% per annum from the
This
date of
irrevocable general power of attorney is unregistered.
unregistered.
And property rights of the property are transferred to you.
Transferred to
By
me.
way of unregistered document.
Registered,
Unregistered document.
registered agreement of sale. One second.
No, unregistered power of attorney.
Oh, yes. Unregistered agreement of sale, my lord. suit was filed on, my lord, 10/11/2008. Ex parte injunction was granted on, my lord, 17/11/2008.
Yes.
Agreement, my lord, executed by first defendant in favor of plaintiff. Ex parte interim order was granted on, my lord, 17/11/2008.
Yes.
In the year 2011, my lord, in the year 2008, my lord, defendant number 1 sold the suit scheduled property in favor of defendant number 2 and 3. Defendant number 2 is the grandson of defendant number 1, and defendant number 2 is the close relative of defendant number 1. Thereafter, my lord, we filed this present suit on, my lord, 10/11/2008. On 17/11/2008, my lord, ex parte interim order was granted by the trial court. In the year 2011, my lord, defendant number 2 and 3 trying to trespass the suit scheduled property, my lord. Therefore, my lord, when there was an interim order.
By any chance, any interlocutory application with regard to this lease deed is filed before the court?
Pardon me?
Any writ petition?
No, it's not right.
Huh? Not filed.
Not filed.
No, that is for seeking some marking of this document, lease deed.
No, I know. I'm not sure about it.
Not right.
Not filed.
What is the suit scheduled property now?
Suit scheduled property is 4060 site.
Vacant site.
Vacant site. When the possession was handed over by the defendant number 1 in the year 1985, my lord, by virtue of the agreement dated so and so, we put up construction.
When did you?
In the year 1985 also. In the year 1985.
You have taken the permission? Permission was taken. What are the documents that are filed to show that have been in possession of the property right from 1985?
We obtained electricity supply, we obtained water supply, and, my lord, we paid revenue to the concerned department.
On whose name?
On my name only. On the basis of that agreement.
Is it correct?
I'll produce the documents.
Not the doc, yes.
I'll deny it. Only thing my learned friend is not well versed in the pleadings on the trial court is concerned. I'll make my submissions. His suit is not for suit for physical performance. His suit for para 74 in page number para 74. Their prayer. Direct the defendant to pay 6 lakhs along with the interest of 18% per annum. Date of sold relation, so on so. It is the major prayer. Second, consequential reliefs said declare the sale deed executed by the first defendant in favor of the defendant 2 and 3. That is this consequential relief. Then nowhere in say call for the defendant to execute the in terms of the 1985 agreement. There is no prayer at all in the pleadings. In addition to that, let's file the suit.
No specific performance.
There is no specific performance at all. They will not plead it in subsequent consequential relief is not all reliefs. Only for damages they retain. Their major prayer is entitled for damages. One thing, because of virtue of 2008.
He didn't even sought for declaration.
He is not for declaration. Just I'll come next there. Because of 2008, they filed the suit. 2013, matter is posted for evidence. They will not lead the evidence. So 2014 suit for dismiss for non-prosecution.
My apologies. When, my lord, when the interim order was absolute, made it absolute on, my lord.
No. It's a fact that
interim order for what? Not to put up construction. That's all. Not to alienate or not to interfere. That is not the interim orders.
2013. It was
that is suit 2014 suit is dismissed. After dismissal of the suit, my client came to know there is no pendency of the suit. She has purchased the property.
When the miscellaneous petition was there.
Wait, I'll complete. 2014, that after there subsequently they filed the miscellaneous for restoration of the suit. They are also made this fourth respondent is also the one of the party respondent in the miscellaneous petition. Miscellaneous petitions is allowed, suit is restored. Then in the present suit, they are also made. Earlier, I am not the party in that suit. Subsequently, they filed the application before the trial court. I am impleaded as one of the defendant in the trial court. After impleaded, my client, they are not single pleadings against my client. They are not amend their pleadings, only added the party, not pleaded against me. And the actual positions of the property. That's why trial court consider all my facts, all my documents. And with the written statement filed by me, I'll take on the contention in the written statement, they'll produce before the honorable court. Ink page number.
No, this 2008 suit is pending till 2024.
2020.
When were you impleaded? When were you impleaded?
There, I pleaded in 2023, 22, 23.
Sale was in?
Sale was in 2008, 14. I purchased the property in 2018. My vendor 2 and 3 are purchased in the 2008. Para, ink page number 75, my return statement. The above suit filed by the plaintiff is not maintainable against the court defendant that there is no pleading.
In the civil,
You will please come to the main order.
Yes.
Order itself. Let's read.
in the civil contempt, rupees cost was imposed to the defendant number 2 and 3, sum of rupees 25,000. Even till date, they have not paid.
Let's see. Defendant number 4.
Lord, kindly see, my lord.
Come to the reasoning.
My lordship may kindly see page number 60, running page. In the middle, my lord, as per page number 60, running page. Got it, my lord? As per order dated 8/8/2019 in miscellaneous number 853 of 2014, the suit came to be restored to its original stage. But the time of order to restore the suit, the court which dealt the case in miscellaneous number 853 of 2014 have not been restored the interim order, if any, granted in the suit. Accordingly, defendant number 4 obtained a registered sale deed dated 11/12/2014 from the registered sale deed dated 13/10/2008 and 11/12/2014 have been passed the better title coupled with the possession from defendant number 1 to defendant number 2 and 3, and in turn defendant number 2 and 3 to defendant number 4. My lordship may kindly see.
Please come to para 10.
From the pleadings and evidence placed by the parties, one thing in true, defendant number 4 is in the possession of the suit scheduled property as on the date of filing of application. The same have also not disputed by the plaintiff. On the other hand, the plaintiff himself in para number 22 of the affidavit annexed to IA number 16, he specifically stated defendant number 4 has illegally put up 14 iron pillars with an intention to put up a shed with iron sheets by encroaching the suit scheduled property illegally. Lordship may kindly see.
No, please complete it, then you can make supposition.
I same have also supported by the photograph which placed by the plaintiff. Law of land said, persons even rank of trespasser can entitle for the injunction. Further, law also have been evolved. One should not be in evict unless in due course of law. As per the pleadings of the parties, not in dispute, 4th defendant is in possession of the suitural property as in the date of filing of the application. With this background of pleadings and based on settled propositions of law, one prudent man can say defendant number 4 is in the possession of the suitural property. She should not be evict from the suit scheduled property unless due course of law. Further, if defendant number 4 illegally encroached the suit scheduled property as contended by the plaintiff at in para number 22 of the affidavit annexed to IA number 16 only. Remedy left with the plaintiff to evict defendant number 4 from the suit scheduled property. As per law, after establishment of right title over the suit scheduled property, unless the plaintiff have do established such of right title over the suit scheduled property, and at stage he would not be in the position to seek for relief of prayer in IA number 16. Further, if once the plaintiff succeed, the suit based on the document placed by him at before the court, automatically defendant number 4 would dies entitles the equity in against the plaintiff on the ground that she knowingly put up the construction at in the suit scheduled property under a defect title. With this factum of observation,
I've seen the order. What is your second?
my lord, kindly see documents which I produced before this court. Document number, my lord, 5. Page number 46. May kindly see for a moment. Page number 46.
Yes.
Page number 54. May kindly see, my lord. Last page. Operative portion.
Yes.
IA 1 filed by the plaintiff is hereby allowed. My application, order 39 rule 1 2 application earlier. IA number 11 filed by the defendant number 2 and 3 under order 39 rule 4 of the Code of Civil Procedure is dismissed. The interim order granted by the court on 11/7/2008 is made absolute. When, my lord, their application has been rejected, defendant number 2 and 3 application has been rejected, my lord, they does not, my lord.
You are defendant number 4.
4. When the matter was posted for evidence, my lord, suit was dismissed for non-prosecution. Immediately, we filed miscellaneous petition.
After how many years?
Immediately 1 month. After dismissal of dismiss for non-prosecution, immediately 1 month we filed for restoration. After filing the miscellaneous petition, they sold defendant number 2 and 3 sold the suit scheduled property in favor of defendant number 4. During the pendency of the miscellaneous petition by violating section 52 of the TP Act, less pendency is up. Thereafter, my lord, thereafter, miscellaneous petition was allowed, suit was restored to its original stage. And, my lord, automatically, my lord, the interim order granted earlier, my lord, is automatically revives. When, my lord, my miscellaneous petition was allowed before the civil court, trial court, the sale deed executed, my lord, by the defendant number 2 and 3 in favor of defendant 4 by violating, my lord, section 52 of the TP Act. Therefore, I made a part, they made as party.
No, when the injunction is granted against defendant 2 and 3, what is that you are in a very better position than them?
Because of injunction in respect of, they are saying that injunction not to put up the constructions earlier, before dismissal of the suit. After dismissal of the suit, at the time of purchasing the property, there is no interim orders in favor of the defendant 1 and 2. Against the, no operations of the orders, sir.
When the suit is pending, how can they sell the property at that point of
The
time?
suit is not pending after dismissal of the suit. We have purchased the property after dismissal of the suit.
Immediately an application for restoration is filed.
We don't know, because of I am the bona fide purchaser.
Not you. The defendants are aware of it.
Even
Notice must be served on them.
Even then, before filing the miscellaneous, we have purchased the property. Before filing the miscellaneous.
No.
We have purchased the property. In addition to that, they are implicated as a fourth defendant in the suit. Implicated as a fourth defendant in the suit. They have not pleaded against me in single word in the plaint. Is not amend the plaint. Not seek any relief against the fourth defendant.
In a suit of 2008, purchasing the properties in 2018 and 19, and till what time an order has been continued, and suddenly saying that I have purchased a property, bona fide purchaser, defendants are not aware, and all these grounds, how can they sustain? How can it be sustained?
One, because of their, I am the purchased the property after they are implemented as a respondent in the miscellaneous sale came to know that.
No, defendant number 2 and 3.
Yes.
They have there is an injunction against the operating against them.
Injunction in respect of not to put up the construction.
If it is not to put up, means you can alienate.
Hello, on that, even then after dismissal of the suit, they are sold the property. After the dismissal of the suit, they are not sold the property.
There be a status quo.
Look, only in respect of, my submission is, my lord, is that because of, I am in possession of the property, I put up the documents, all the documents which are necessary with the pleadings, my written statement. They are not only impleaded as a defendant. They are not pleaded. How can they file the application for major relief is not in the plaint against the fourth defendant? How can it file the application for injunction application against me? Their injunction application is only.
I will say the technicality, then ask them to implead you.
It's not the technicality.
Give them permission to do it. That's some simple
Not even in future they do anything. We are not as per law they do anything. I have not objected because of the law is provided. They do any amendment and other things.
We didn't sought for injunction against the
only in respect of what their application is concerned.
Right, we sought for injunction against defendant number 2 and 3.
Their application injunction 16
on 12/11/2014.
Who is putting up the construction?
I am in possession, my lord.
No, that is wrong.
I am in possession.
Their injunction application
I am
itself
in
is not
possession.
to put up the further construction.
Switch off that mic.
My lord, on 12/11/2014, we filed, my lord, miscellaneous petition. On 11/12/2014, immediately after 1 month, defendant number 2 and 3 sold the suit settled property.
Anyhow, now you have impleted them.
We have impleted in the miscellaneous petition. In the miscellaneous petition, we have impleted them.
No relief is sought.
No relief is sought.
In the miscellaneous petition, my lord.
No relief is
No,
sought.
one second. In the miscellaneous petition, why we filed out of 39 rule 1 and 2 application. Status quo order was granted on, my lord, 13/4/2015. Anyhow, my lord, my miscellaneous petition was filed on, my lord, 12/11/2014. On, my lord, immediately after 1 month, on 11/12/2014, they sold to defendant number 4.
We'll consider all those technical displacements. Appeal is allowed and an order of, there shall be an order of status quo in the pendency, and this is suit
My
of.
submission.
1 minute, this is a suit of, I'll hear, this is a suit of 2005. 2008, the suit itself shall be disposed of within a period of 6 weeks, 6 months from the date of receipt of the copy of the order. Yes.
Their application itself is not to put up the further constructions. Their application in appeal also, they are not to interfere or anything. Their application itself is not to put up the further
Then we
constructions.
will grant that. So instead of status quo, that then we'll grant that, not to put up any construction till the disposal of the.
3 months I please to put up
Six-
because of
six-
2008.
6 months,
They are
ma'am.
not 100%. They are not going to believe evidence.
6.
For the court, 6 months. To 3 months, it's not possible for the court. There must be pending matters. That's why.
Any evidence will be posted for evidence for plaintiff.
3 months. 3 months.
My lord, 6 months.
No,
My lord,
because of their
my lordship-
their own
You
thing, they are
can't,
waiting for the interim order.
My lord, my lord, may I make one submission?
Please
Kindly-
understand when the matter has to be disposed is not your concern.
Yes,
It is the
please.
court's concern.
Kindly 6 months, my lord. Kindly, my lordship.
Then,
no.
then we'll say, that is no interim order.
No.
Dismissed.
My apologies, my lord. My
Appeal
apologies, my lord.
dismissed, and the.
My
because
apologies,
the suit of so and so, the court shall dispose of the same within 1 year.
My lord, my lordship, 3 months, man.
Yes,
3 months, man.
yes.
My
3 months.
apologies, man.
3 months not to put up any construction.
Please.
Will dictate the further order. Yes. What is the past? 40?
40? 40? Yeah, Manjunath.
Represent the petitioner. But the respondent is the wife of the petitioner.
Where is the respondent?
They are not appearing, right?
Last time also they did.
Last time also they are.
Representation. We'll have it tomorrow on the top of the list, this matter. Yes.
Till number 41?
Uh,
41?
Respondent.
Today also, there is no representation on behalf of the respondent. Pose this matter on the top of the list. Yes.
Till number 41?
For the respondent. 41, my lordship, I am appearing for the petitioner. The DD, driver of the DD was death ಆಗಿದ್ದಾರೆ. Memo file ಮಾಡಿದೀವಿ, put up ಆಗಿಲ್ಲ. Kindly put up this memo.
In this case, what has happened?
What is this revalidation of the demand draft?
Demand draft, that is to be revalidated.
Have you done it?
No.
Then what is that you want?
Their submission is, who drawn the DD is died. The father of the petitioner drawn the DD, so he died it seems. That's what he furnished the death certificate of the father. No, to
Then
revalidate.
who are contesting this matter?
I am up for the respondent.
No, for the petitioner.
Petitioner,
I am appearing for.
No, he's no more.
no, petitioner is.
Petitioner is the petition, father was there.
Beyond.
Then let the petitioner take a demand draft.
Please, I, therefore kindly next week, my lordship.
It is submitted that the earlier demand draft was taken by the petitioner's father and he is no more. So hence he cannot revalidate the sent demand draft. The petitioner shall place the demand draft, a new one, by the next date of hearing.
They informed me, since the direction is, if the direction is given to the bank, only it's a revalidation. Revalidation, the bank can do, but only thing is direction is required.
Why, where is a bank is a party to this? The demand draft shall be placed before the court by the next date of hearing. Pose this matter on 9 September?
Much.
Yes.
Lordship, serial number 26. Serial number 26. I pay for respondent, my lordship. My lordship, the court has sent a letter for extension of time in this.
That is done.
90 days. Grateful, my lordship.
Number 31. Number 31. Only.
All the matters, time is granted. A week's time.
Since it was 4:15.
No, it's 2/4/15, that's why all,
Please.
Serial number
That's right.
70. I'm the party in person. Petitioner.
you are the party in person. Serial number? I was under the impression that you are a party, you are representing it on behalf of your advocate.
No, madam, what happened is it was serial number 8 was taking so much of time. You were just sitting here. By the time we
Which
came-
case is yours?
17, madam.
1/7. Oh, that is dismissed in the morning. Is it signed? Tomorrow?
Tomorrow.
Because again, will not give you another opportunity to mention.
Let me present now only. That's not an issue. My
No,
only,
no, it is not possible.
my only submission is, madam, before you.
What
take
is
up-
that? Right from 2013, why are you not complying with the office objections?
My lord, I mean, more than that, actually, this is about the visitation, my lord.
So that we will take care. Now it is coming for non-rectification of office objections raised on IA number 2 of 14. What is that?
Not a severe objection, my lord. In fact, it may be very small, minor objection.
What is that?
Okay. I also don't know, because I just got a call from High Court.
You don't
2
have
days
the
back.
file?
My lord, that's what I mean. I got a call from High Court only 2 days back. That case is posted yesterday. Okay, and
No,
yesterday.
correct. Now how will you argue without papers?
My lord, I'll get that paper. That's why I thought, if
Pose
it
this
is
matter,
next
same,
week- next
pose
week
this
and also, my
matter,
lord,
next to Wednesday.
Yes, madam. And also.
Delete from the
respondent-
caption dismissal.
My lord, the respondent can be ordered to come appear, that would be good, my lord.
They will, if they don't appear, they will be doing at the risk of their client. They will be doing at the risk of their
I
client.
agree, madam. I can share the phone number of the respondent if something can be
Please.
communicated, because
That is not the problem of the court to communicate to the party.
but in the
It is
interest
a
of justice,
notice is served. If she is not coming, what we can do?
today also they have not come.
Because she is not, neither, she's appeared through an advocate, nor she has filed any petition to appear as party in person. Yes. Which petition? That is allowed.
Yeah, my humble request was if something can be communicated to the respondent so that they can come
That's
face to
not,
face.
that is, for you are a party in person, it is communicated. For a party for whom notice is served, there is no procedure to communicate to them.
ಒಂದು ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಕಳಿಸ್ತಾ ಇರು ಮೇಡಮ್, ನಿಮ್ಗೊಂದು ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಆಗಿದೆ. ಇಲ್ಲ ಇಲ್ಲ, ರೀಕಾಲ್ಡ್ ರೆಸ್ಟೋರ್ಡ್ ರೀಕಾಲ್ಡ್ ಅಂಡ್ 18 ಅಲ್ಲೇ ಮೇಡಮ್. ಇಲ್ಲಿ ನೋಡಿ, ಬೋತ್ IAS ಆರ್ ಅಲೋಡ್ ರೆಸ್ಟೋರ್ಡ್ 1 week ಟೈಮ್ ಗ್ರಾಂಟೆಡ್, ಫೈಲಿಂಗ್ಸ್ ಆರ್ ಡಿಸ್ಮಿಸ್ ಅಂತ ಮತ್ತೆ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ, ಡಿಲೇ ಕಂಡೌನ್ ಅಲ್ಲ, ಇದಕ್ಕೂ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್. 2084 days ಡಿಲೇ ಇಸ್ ಕಂಡೌನ್ಡ್. ಅದಕ್ಕೆ ರೀಸನ್ಸ್ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್. ರೀಸನ್ಸ್ ಹೇಳಿ ಡಿಲೇ ಕಂಡೌನ್ಡ್ ಕಾಲು ಮಾಡಿದ್ರೆ. ಅಲ್ಲಲ್ಲ, ಅಲ್ಲಿ ಅದಾದ್ಮೇಲೆ ಮೇಡಮ್ ಆಫೀಸ್ ವಿತಿನ್ ಎ ಪೀರಿಯಡ್ ಆಫ್ 1 week ಹೇಳಿದ್ದಾರೆ.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಪೋಸ್ಟ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಹೇಳಿದ್ದಾರೆ.
ಅದೇ ಅದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನೋ ಇದೆ. 27th 17 28 8. ಇದು DNP ಇಲ್ಲ ಮೇಡಮ್. ಸೇಲ್ ನಂಬರ್ 17
ಅದು DNP ಇಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ ಕಳಿಸಲ್ಲ ಫೈಲ್.
17 ಇದು ತಗೊಳ್ಳಿ, ಇದೊಂದೇ ನಿಮ್ದು. ಏನಾದ್ರೂ ಮಾಡಿ. ಆನ್ ದಿ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಒಂದು ಐತೆ ನೋಡು. ಒಂದಾಯ್ತು ನೋಡು, ಆನ್ ದಿ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಟುಮಾರೋ. ಯಾವ್ದು ಅದು ಸೀರಿಯಲ್ ನಂಬರು? 1 ನಿಮಿಷ. 40 serial number 40 on the top of the list tomorrow. We are Manjunath. Top of the list 21 sir. 38 ಅಲ್ಲಿ ಬೆಳಗ್ಗೆನೆ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು ಟೈಮು. 1 week failing stands dismissed. ಇದು ಆನ್ ದಿ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್. ನೀವೇ ಬರ್ಬಿಡಿ. ಇದೊಂದು 40
ಸೈನ್ ಮಾಡ್ಬೇಕಲ್ಲ. 25
ಮೇಘ
ಆಮೇಲೆ ಫೈಲ್ ನೆನ್ನೆದು ಇವತ್ತು ಡೇಟ್ ಇತ್ತಂತೆ 25
ಫೈಲ್ ನಂಬರ್ ಗೊತ್ತಾಗೋದಿಲ್ಲ. ಬಿಕಾಸ್ ಎವ್ರಿ
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವಾಗ ಫೈಲ್ ಕಳಿಸ್ಲಾ ನಾಳೆ?
ನಾಳೆಗೆ ಆಗಲ್ಲ, ಇವಾಗ ಕಳ್ಸಿದ್ರೆ ಕ್ಲೋಸ್ ಆಗ್ಬಿಟ್ಟಿರುತ್ತೆ. 4 ಕಾಲು ಆಲ್ರೆಡಿ. ಇವಾಗ ನೋಡಿ, ನಾಳೆಗೆ ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಇದೆ? ಅದು ಏನು ಇವತ್ತು ಬಿಟ್ಟು, ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿರೋನ್ನ ಬಿಟ್ಟು ನಾಳೆ
ಬೆಳಿಗ್ಗೆ ಕಳಿಸಿದೆ ನಿಮ್ಗೆ.
ಏನ್ ಮಾಡಿ ಈಗ ಸೈನ್ ಆಯ್ತಾ ಮೇಡಮ್?
ಆರ್ಡರ್ ಬರ್ದಿರಲಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಈಗ ಬರ್ಬಿಟ್ಟು ಸೈನ್ ಹಾಕ್ಸ್ಬಿಟ್ಟು ಬೆಳಗ್ಗೆ ಕಳ್ಸಿ. ಹಿಂದೆಗೋ ಹಾಕ್ಸ್ತೀನಿ ಅಷ್ಟೇ. ಅಥವಾ ನಾಡಿದ್ದಕ್ಕೆ ಎಷ್ಟಿದೆ? ನಾಡಿದ್ದು 22ಕ್ಕೆ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದೆ ನೋಡಿ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 40 Serial number 40 date given matter you have won. 40 on the top of the list tomorrow. Last ಇದು ಕೊಟ್ಬಿಟ್ಟು ಸೈನ್ ಮಾಡಿ
Repeat ಆಗ್ಬೇಕು.
Madam, 41.
No, there are so many. Tomorrow there are after nearly 50 matters
Sure,
already listed.
ಎಲ್ಲ ನೀವೇ ಬರ್ಕೊಳ್ಳೋದು. 41 ಇದು.
41.
ಹೌದಾ? Madam wants to see white list.
ಅಯ್ಯೋ, ಮೇಡಮ್ ನೀವು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು 39.
39 allowed.
ನಾನು ಹಂಗೆ ಕಳ್ಸ್ಕೊಳ್ತಾ ಇದ್ದೆ ಈಗ.
ಓಕೆ ಓಕೆ
White list ಬೇಕಂತೆ ನೋಡಿ.
ಎಲ್ಲ ಫಿನಿಶ್ ಆದ್ಮೇಲೆ
No, sir, okay, sir. ಇವರು ಲಲಿತಾ ಅವರು ಕೊಡಿ.
Today it is in.
Okay. Okay. ಲಲಿತಾ, ಅಂದ್ರೆ ನೀವು ಇತ್ತಲ್ಲ, ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಯಾಕೆ ಗೊತ್ತಾ, ನಿಮಗೆ ಇವತ್ತು 4 wait ಮಾಡೋದು, ಅದಕ್ಕೆ don't put the time there. Actually, last question, madam asked put the time, let them not wait. But today, the matter is listed so fast. ಅದಕ್ಕೆ ಇವಾಗ ಆಮೇಲೆ ವೈಟ್ ಲಿಸ್ಟ್ ಬೇಕಂತೆ, ಫೈನಲೈಸೇಷನ್ ಆಗಿರೋದು ವೈಟ್ ಲಿಸ್ಟ್ ಅಂತ ಕೊಡ್ತೀವಿ. 3 ಮ್ಯಾಟರ್ ರಿಪೀಟ್ ಇದೆ, ಹೇಳ್ತೀನಿ. ನಿಮಿಷ ಹಂಗೆ ಹೇಳ, ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಕೊಂಡ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತಾ? 80/23. ಆಮೇಲೆ MFA 47/24. ಆಮೇಲೆ ಇನ್ನೊಂದು 1 ನಿಮಿಷ ಹಂಗೆ ಇರು. 12/9/37 of 19, no? P7 WP. WP 12/9/37 of 19, no? On the top of the list. WP 12/9/37 on the top of the list. ಇನ್ನು ಉಳಿದಿದೆ ಮಾಮೂಲಿ. ಈಗ ವೈಟ್ ಲಿಸ್ಟ್ ಫೈನಲೈಸ್ ಮಾಡಿ ಬೇಗ ಮೇಡಮ್ಗೆ ನಮಗೂ ಕೊಡಿ ಒಂದು ಲಿಸ್ಟ್. 3 ಮ್ಯಾಟರ್ ಆಡ್ ಮಾಡ್ಬೋದು. ಯಾರು ಎಲ್ಲಿಂದ ಅವ್ರಿಗೆ ಹೇಳಿ, ಇವಾಗ ವೈಟ್ ಲಿಸ್ಟ್ ಕೇಳ್ತಿದ್ದಾರೆ, ಬೇಗ ಕಳಿಸಿ ಮೇಡಮ್ ಅಂತ. ಸರ್ 41 ಅದೇ ನ್ಯೂ ಡಿಡಿ ತಗೊಂಡ್ ಬನ್ನಿ. ಅಲ್ಲ, ದಟ್ ಲೆಟ್ ದಮ್ ದಟ್ ಪಾರ್ಟಿ ಪರ್ಚೇಸ್ ಅಂತ ಹೇಳಿದ್ರು. ಪಾರ್ಟಿನೇ ತರ್ಲಿ, ಪಾರ್ಟಿಗೆ ತಗೊಂಡ್ ಬರಕ್ ಹೇಳಿ. ಲೆಟ್ ದಮ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ನ್ಯೂ ಡಿಡಿ. ಅಲ್ಲ, ಪಾರ್ಟಿ ಅಲ್ವಂತಲ್ಲ, ಫಾದರ್ ಅಂತಲ್ಲ. ಅದಕ್ಕೇನೆ ಲೆಟ್ ಹಿಮ್ ಬೈ ದಿ ನ್ಯೂ ಡಿಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಹೇಳಿ, ಅದನ್ನ ರಿವ್ಯಾಲಿಡೇಟ್ ಮಾಡಿ ನಮಗೆ 9999 415 ಅದು ಬೇಗ ಬೇಗ ರೀಚ್ ಆಗ್ಬಿಡ್ತು. ಅವ್ರಿದ್ರು ಇವ್ರಿದ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್, ಅದು ಧೀರೇಂದ್ರ ಎನ್ ಕಟ್ಟಿ, ನ್ಯೂ ಪಿಟಿಷನರು. ಅದೇ ರಿವ್ಯಾಲಿಡೇಟ್ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ಪಾರ್ಟಿ ಎಕ್ಸ್ಪೈರ್ಡ್, ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ಈಗ ನೀವ್ ಹೇಳಿ, ನೆಕ್ಸ್ಟ್ 9/9 ಡೇಟ್ ಇದೆ ಸರ್, ಆನ್ ದಟ್ ಡೇ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಯಾಕೆಂತಂದ್ರೆ ದೇರ್ ಇಸ್ ನೋ ಮನಿ ವಿತ್ ಹಿಮ್, ದಟ್ ಲೆಟ್ ಫಾದರ್ ಪರ್ಚೇಸ್ ದಟ್ ಡಿಡಿ ಮೇ ಬಿ ರಿವ್ಯಾಲಿಡೇಟೆಡ್ ಅಂತ. ಅವರು ಮೇಡಮ್ ವೈ ಶುಡ್ ಐ ರಿವ್ಯಾಲಿಡೇಟ್, ಇಟ್ ಇಸ್ ಲ್ಯಾಪ್ಸ್ ಲಾಂಗ್ ಬ್ಯಾಕ್ ಅಂತಾರೆ.
ಅದೊಂದೇ ಅಲ್ಲ, ರಿವ್ಯಾಲಿಡೇಷನ್ ಯಾರು ಮಾಡ್ಬೋದು, ನಾವು ಮಾಡಕ್ ಬರಲ್ಲ. ರಿವ್ಯಾಲಿಡೇಷನ್ ಮಾಡ್ಬೋದು.
ರಶ್ಮಿ ರಾವ್, ಈಗ ನೀವು ಇದು ಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತಾ?
ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ ಇನ್ ಟೈಮ್ ನಾವು.
ಅಯ್ಯೋ ಹಂಗೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಹೋಗ್ಲಿ ಬರೀ ಕಳ್ಳಿ.
ಹಿಂಗೆ ಹೇಳ್ತಿದ್ದೀನಿ. ಮೇಡಮ್ ಇದ್ರೆ ಅವ್ರಿಗೇನ್ ಹೇಳ್ತಿರ್ಲಿಲ್ಲ ಬಟ್ ರಿಜಿಸ್ಟ್ರಿ ಪ್ರಾಬ್ಲಮ್ ಇರೋದು.